Greetings from across the world. We welcome you to ICJ Kenya. We welcome you to ICJ Kenya House for this important discussion where we will be unpacking the Supreme Court decision on the Building Bridges Initiative and the Constitutional Amendment Bill. I am joined by eminent panelists here and also online. So this discourse brings together people from not only Nairobi, Kenya, but Australia, India, and also the US. So we will begin by starting with the national prayer, which is the national anthem. Thank you very much, technical team, for that. I'd like to introduce, first of all, my co-moderator. I am Julie Wayo-Madheka. I work at the ICJ Kenya. I'm a program manager, and today's session will be co-moderated by Ms. Valentine Haminwa.
Thank you, Julie, and good afternoon, ladies and gentlemen. I'm Valentine Haminwa, as mentioned. On our panel today, we have the distinct privilege of hosting eminent scholars from around the world. Our first panelist is Professor Rosalind Dixon, who's a professor of law and a director of the Gilbert and Tobin Centre of Public Law at the University of New South Wales in Sydney, Australia. And she's the immediate past co-president of the International Society of Public Law. Secondly, we have Dr. Adem Abebe. Dr. Abebe supports constitution building and dialogue processes, particularly in politically complex contexts, as part of the International Institute for Democracy and Electoral Assistance. He convenes platforms for dialogue and provides technical assistance to high-level decision makers at national and international level across the world. He advises and trains civil society stakeholders in diverse contexts around the world. He has published numerous op-eds in prominent forums, some of which include the Foreign Policy Journal and The Conversation, as well as many Ethiopian outlets. He has regularly appeared as a commentator on major global radio and television networks, including BBC, Al Jazeera, France 24, TRT World News, and many others. He has published in prominent academic journals on comparative constitutional law and practice. Adam serves as the Vice President of the African Network of Constitutional Law. He's on the advisory board of the International Journal of Constitutional Law, as an extraordinary lecturer at the University of Pretoria in South Africa, and he's also a fellow at our Kabarak University. He has been invited as a neutral expert, or what we call amicus curiae, in prominent court cases, including by the Ethiopian Council of Constitutional Inquiry, as well as the Kenyan Supreme Court. Thirdly, we're also honored to have Dr. Gautam Bhatia. Dr. Bhatia is an Indian constitutional lawyer and scholar. He's a graduate of the National School of India University, Yale Law School, and the University of Oxford in the United Kingdom, where he finished his doctorate in philosophy. He's also a doctoral research fellow at Scripps Center for Excellence in Humboldt. And he's also the author of a renowned book called Offend, Shock, or Disturb: Freedom of Speech Under the Indian Constitution, the Transformative Constitution, as well as numerous other articles in journals such as the Global Constitutionalism, the Constitutional Court Review, and the Max Planck Encyclopedia of Comparative Constitutional Law. His work has been cited by the Indian Supreme Court, and he was one of the amici curiae in the recent Building Bridges Consolidated petitions in Kenya before the Supreme Court.
Thank you very much, Valentine, for introducing our online panel. Now I have the distinct pleasure of introducing our Nairobi panel. We are joined by Ms. Christine Konge, who is the Executive Director at the Katiba Institute. The Katiba Institute is an organization based in Nairobi which works to promote constitutionalism and the rule of law in Kenya. Christine practices constitutional law as a public interest litigator and has appeared regularly at the High Court, Court of Appeal, and Supreme Court on groundbreaking constitutional matters. Christine has also significant experience in criminal law, women and children's rights. Christine holds a Bachelor of Laws degree from the University of Nairobi, a Master's of Law in Human Rights from the Central European University in Hungary, and she's also an advocate of the High Court of Kenya. Thank you very much, Christine. On our far side, we have Professor Ben Sihanya. He is an intellectual property and constitutional law professor at law at the University of Nairobi. He holds a JSD, JSM Stanford, LLM Warwick, LLB University of Nairobi, and a postgraduate diploma from the Kenya School of Law, amongst many others. He is a mentor and public interest advocate in constitutional democracy. He is also a public intellectual and a poet. Our last but certainly not least panelist is Mr. Ochel Dudley, a familiar face on our Twitter space, but also in our courts. He is an advocate of the High Court. He served as counsel as one of the respondents before the Supreme Court in Kenya and in the BBI appeal. So he is one of our advocates who actually served at the Supreme Court. We thank our eminent panel for joining us, and we hope that this is going to be a very robust and in-depth discussion. To kickstart us off, we would like to hear and officially grace this occasion by opening it with words from the Executive Director of the Kenya section of the International Commission of Jurists, Ms. Elsie Saina. Please officially open for us this conversation.
Thank you very much, Julie and Valentine. It's my distinct honor, ladies and gentlemen, our distinguished guests and panelists, colleagues, and all those joining us from the ICJ Kenya House to say good afternoon. Good afternoon once again. On behalf of the ICJ Kenya Chairman, Mr. Protest Saende, and the entire ICJ Kenya fraternity, our partners, the Katiba Institute, Kabarak University School of Law, and the Avid Readers Forum, and the Konrad Adenauer Foundation, it is really our pleasure to invite you to join us for much anticipated discussion this afternoon. This convening comes just a week after the Supreme Court of Kenya rendered its decision in what can arguably be referred to as the most significant decision after the Supreme Court nullification of the 2017 presidential elections. This judicial decision and ensuing reactions and conversations by members of the public, academia, civil society has really given us opportunity to inform what is coming up in our legal, constitutional, as well as socio-political context, not only in Kenya, but also in the region. I recall a similar conversation we held right here at the ICJ Kenya House on the 27th of August, 2021, as part of the Katiba at 10 series celebrations. And together with the partners represented here today, we also interrogated the Court of Appeal judgment on the same subject matter. It would be interesting to compare the outcomes of the Court of Appeal as well as for that we'll be discussing this afternoon. Based on the ICJ Kenya statement that we issued on the 1st of April 2022, in response to the judgment, we committed together with the partners to jumpstart this discourse, and we're excited to have it this afternoon. As we begin the conversations, colleagues, to unpack the judgment, we must ask ourselves what this judgment means in the light of not only the upcoming general elections, but also what it means for Kenya in terms of our constitutionalism and the rule of law. With less than 3 months before our general elections, we must focus our efforts to remind those who want to claw back at our constitution that we will remain vigilant in ensuring that we vigorously defend the will of the people of Kenya. Finally, allow me once again to express my sincere gratitude to the panelists, to our partners, and invite the participants to our robust engagement this afternoon. Once again, karibuni sana to this wonderful webinar. Thank you, Julie. Back to you, Julie and Valentine.
Thank you very much, Elsie. Indeed, this is a timely discussion. I feel like every Kenyan wants to know, how does this decision impact the election that is coming? How does the Supreme Court posture? This was our first landmark decision in the land. So there are very many discussions that we will have today that will be contributing to the statement that was issued by ICJ Kenya a while back. I wish to invite our other co-convener, Mr. Peter Wendo, to give us a word from the Konrad Adenauer Stiftung. Mr. Peter Wendo is the program advisor at the foundation, a long-serving friend to ICJ Kenya, Katiba, and Kabarak, And we are glad that you could make it online to just share your thoughts with us. So welcome to give your opening remarks.
Thank you very much, Julie. Thank you, all distinguished panelists and all those who are joining us from different parts of the world. I take this opportunity to also welcome you in the name of Konrad Adenauer Foundation, which is a German foundation that aims to promote freedom, justice, and solidarity around the world. I also wish to pass our the regards of our director, Dr. Stephanie Rothenberger, who unfortunately cannot join us because she's on official travel back in Germany. The Konrad Adenauer Foundation, and in particular the Rule of Law Program for Sub-Saharan Africa, is indeed delighted to be associated with this activity as we endeavor to support initiatives in the region that are geared towards the promotion and protection of constitutionalism, independence of the judiciary, principles of separation of powers, democracy, human rights, and other pertinent aspects of the rule of law. Constitutionalism and independence of the judiciary are indeed at the core of today's discourse as we unpack, or we try to unpack the recent decision of the Supreme Court. From the onset, and picking up from what Elsie just said, what should not be lost on us is that this judgment was a victory not for and not of politicians, but of ordinary citizens. It is the men and women who are found in the markets, on the Pangani, Kangemi, Kawangware buses and matatus, and housewives, as was described by Justice Madan, who began the legal battle. It is Dr. David Lee and the others who are to be celebrated, and from whom other ordinary citizens, and particularly in Africa, should draw inspiration and courage in defending their constitutions. The judgment, to a large extent, affirms and restores supremacy of the Constitution itself on one hand, and the sovereign power of the people on the other. These are indeed important ingredients in the realization of an all-inclusive and just society that is governed under the tenets of the rule of law. And learning from our history, as we deliberate on the impact of the judgment, I will ask all of us to spare our thoughts for the gallant courts. As a people who have donated judicial power to the courts to serve us and our interests in pursuit of justice, are we ready to defend and stand up for the judiciary if they are to be revisited? This often manifests in loud bangs and sometimes subtle maneuvers. I am sure the Kenyans in the house today, you are aware of what happened yesterday in terms of the resources that were allocated to the judiciary when the national budget was read yesterday. It is our hope that today's discourse will contribute to the useful analysis and debates that will follow in the days, weeks, and months to come, and that this landmark ruling will offer great insights to the students and enthusiasts of constitutional law, not only in Kenya and Africa, but also around the world. From Konrad Adenauer Foundation, I wish you fruitful deliberations, and thank you all for joining us. Thank you.
Thank you very much, Peter. We appreciate the partnership we have had with CAS, and indeed, what you have said resonates with every single person. It's unfortunate that whereas the courts have stood for Wanjiku, they are more often revisited and their budgets are slashed. We take cognizance of the fact that the budget has been read in this administration, and it is indeed our hope that the judiciary funding will be secured as well as increased in the future time. Now, I think one thing that we can say is the discourse on BBI and constitutional amendment has been ongoing for a year. We have moved from the High Court to the Court of Appeal to the Supreme Court. And various things have changed, but others have stayed the same. So for us to contextualize and have scope of this discourse, I wish to invite Mr. Elisha Ongoya to lay context and introduce what exactly we will be tackling in this webinar today. Over to you, Mr. Ongoya.
Apologies, we cannot really hear him.
Sorry, we can't hear Mr. Ongoya.
We cannot hear Mr. Ongoya.
On the 28th of March 2022, when she signed and dispatched the judgment notice in respect of these three consolidated petitions of appeal, namely petition number 12 of 2021, 11 of 2021, and 13 of 2021, popularly called the Honorable, the Attorney General, and others, versus David D. and others.
Mr. Ongoya, I will stop you just a little bit. There seems to be a technical issue. So allow me to pass my microphone to you. I am sure they've been able to hear me before.
Thank you, Julie, and thank you, everyone. My apologies for that technical hitch. I'll pick it up once again. My name is Elisha Ongoya, Senior Lecturer at the Kabarak University School of Law and convener of the Avid Readers Forum of the Kabarak University School of Law. I am inspired by the words of Professor Robert Kagan, a law professor and a political science professor at the University of California at Berkeley, who said that decisions of constitutional courts often are like volcanic eruptions, reshaping the landscape of political and administrative action, usually in small ways, occasionally in large ways. Constitutional litigation has also become a well-established form of political action, since political groups, having failed to get their way in legislative or administrative agencies, frequently ask courts to overturn legislative or administrative actions or policies on grounds that they violate principles inferred from the Constitution. Judges sometimes agree and ask governments to take remedial actions. I want the BBI judgment from the High Court, the Court of Appeal, and the Supreme Court to be understood in that context. On the 28th of March 2022, when she signed and dispatched the judgment notice in respect of three consolidated petitions of appeal, namely number 12 of 2021, number 11 of 2021, and number 13 of 2021, also known as the Attorney General and others versus David D. and others, or in short, the BBI appeal, my very good friend and registrar of the Supreme Court of Kenya, Honorable Letizia Wachira, had signaled that the 31st of March 2022 was not going to be an ordinary day in the life, the times, and the history of the Supreme Court of Kenya. And so it came to pass. The Supreme Court of Kenya has spoken. The address by the Supreme Court of Kenya has brought to an end, at least for now, the judicialized journey in Kenyan domestic courts that began at the High Court, essentially challenging the constitutionality of the Constitution of Kenya Amendment Bill 2020, also known as the BBI Bill. The intellectual journey, on the other hand, is not about to end. I suggest it has just begun. Whatever had happened before this was a mere dress rehearsal, or what you call in sports, a warm-up session. It is now in the public domain that on that day, the 31st of March, the year 2022, the Supreme Court of Kenya rendered null and void the Constitution of Kenya Amendment Bill 2020. But that is not the most important intellectual development of that day. It is the reasoning of the Supreme Court on the 7 issues around which the constitutional validity or invalidity of the BBI bill had been hinged that is of intellectual interest. The questions that concern the Supreme Court and which concern us are the basic structure and the basic structure doctrine. What is the meaning? What is the nature? What is the character? What is the applicability of that creature? Number 2, amendment of the Constitution by popular initiative. What is the place and role of the president in that process? Creation of constituencies, which in the Kenyan context are units of representation. Whose responsibility is it? How and when should it be done? Presidential immunity. What does it mean? What are the viable and acceptable options of holding the president accountable? Effective public participation. What is the constitutional threshold? To what extent can it be ignored or disregarded, if at all that is a possibility? What is the appropriate quorum of the elections management body in Kenya, the Independent Electoral and Boundaries Commission, IEBC? Referendum questions. How should they be framed? How should they be presented? Kabarak University School of Law, through its avid readers forum, prides itself in the acquisition of knowledge by engaging with intellectually stimulating material. The forum has held many such conversations in the past. In this context, it has partnered with the International Commission of Jurists, Kenyan section, the Katiba Institute, the Konrad Adenauer Stiftung, to assemble us here today for an intellectual conversation on the immediate and long-term significance of what the Supreme Court said on 31st of March 2022. Or perhaps what the Supreme Court didn't say on 31st of March 2022. Welcome to the battleground of ideas. Karibuni nyote.
Thank you, Senior Lecturer Ongoya. That's a good overview. Now we're actually going to go into the substantive unpacking of the judgment. And we're going to start with Christine Nkonge of Katiba Institute. And please, can you share your thoughts on the judgment and particularly on the question of presidential immunity? And you can reserve the issue of basic structure for later on in the presentation, please. Thank you.
Okay. Thank you so much, Val. It's good? Okay, I'll go on. Can you hear me? I hope so. Thank you so much, Val. And we'll just go straight into the topic that was assigned to me, and that is the issue of presidential immunity, one of the 7 questions put to the Supreme Court for determination. To contextualize the issue, this issue arose at the High Court level from the petition filed by Isaac Alocher. And the context was, or the premise was that by setting up the 2 task forces, the BBI task forces, allowing that task force, especially the second one, suggest changes to the constitution, then the president was acting outside his authority as granted by the constitution. And therefore, if he was so acting outside the authority granted to him by the constitution, then the question that follows is, can he be sued in his personal capacity for the violation against the constitution that he made through the creation of these 2 task forces and actually allowing the use of public resources to move those 2 processes? So at the High Court level, the question was framed under Article 143 of the Constitution. That is where we find the clause on presidential immunity or protection from legal proceedings for the president. So that is where this issue under the Constitution is actually situated. So the court then, at the High Court, as provided by one of the judges in the Supreme Court, asked itself that if the president is not acting through powers donated by the Constitution or extra constitutional powers, then can he be sued as the president as opposed to the president of the Republic of Kenya? Can he be sued as an individual, Mr. Uhuru Kenyatta, as opposed to the president of the Republic of Kenya, Mr. Uhuru Kenyatta? So that was the context. And you know, at the High Court, the judges found that for them, the operative words was anything done or not done under the Constitution. So if it was anything that he did that was outside the Constitution, their reading of that provision indicated that he could be sued in his personal capacity because the Constitution only protected actions that are done by the president in his duty as a president that are within the Constitution. And the Court of Appeal, to a large extent, with some judges dissenting, upheld that position by the High Court. So this then now through the appeal by the president at the Supreme Court, then fell for determination by the Supreme Court. And all of the judges, this was a unanimous decision, did find that the president has immunity under the Constitution. And they, you know, immunity usually donated to certain offices under the Constitution, so that the president therefore enjoys sovereign immunity as a head of state, and then also enjoys functional immunity on the basis of some of the responsibilities he has under the Constitution. Then they looked at, so they looked at actually the issue of whether he's immune for prosecution during his tenure under civil proceedings, because also at the High Court and Court of Appeal, they said he's immune from criminal proceedings unless those proceedings that are allowed by treaty. So they were actually looking at the issue of civil proceedings. And so this is where the court then went on to find to them, really there's no distinction as such between the president and the individual in exercise of his powers. And they said the reason why their reading of this provision meant that the president has immunity from civil prosecution during his tenure is because, for example, as was provided by one of the judges of the Supreme Court, that to allow the president to be subject to civil proceedings would mean that he would be subject to court attendances, he would be subject to, you know, being cross-examined, and even if found liable to the execution processes that fall thereafter, including, you know, admission to civil jail if it does not respect certain court orders. And they said this would definitely detract from his responsibilities as the head of state. They even did indicate that even if his interpretation of, because in applying his duties, the president does interpret the Constitution, and it does make a determination that my reading of this provision means I can take this action or not take this action. And they indicated that even if his interpretation of the Constitution was wrong, that is still something within the function of office, and therefore still fell under the immunity clause. So they, in a nutshell, that therefore it meant the president cannot be sued in his personal capacity, but can be sued as a president of the Republic through the office of the Attorney General, through the powers provided to the Attorney General under Article 156(4) of the Constitution. And the court did say that that has been the practice, that they are looking at the jurisprudence that has emanated from the courts. They found that the president has been challenged. His decisions have been challenged numerous times. through an action through the Office of the Attorney General. They did not find any incident where the president was sued in his personal capacity, except in this instance by Mr. Isaac Alocher. Even in the Katiba Institute case, also on which another aspect was presidential immunity, the court did find that listing the President of the Republic of Kenya in the petition was a misjoinder, that it was enough to just sue through the Office of the Attorney General. So for me, these are the consequences, or this is the impact of this decision. You cannot sue the president in his personal capacity. You cannot sue him as Mr. Uhuru Kenyatta for anything that he does in his official capacity. But if it's anything that is not related to his official duties, that does not give him any immunity from civil proceedings. However, for exercise of public power in his official capacity, his actions or inactions can be challenged either by judicial review, constitutional petition, through the Office of the Attorney General, or it can be disciplined, as I would put it, through the impeachment process, the removal of the president through the impeachment process. Those are the options that the Supreme Court gave. That really is okay, because it doesn't mean, I think the central fear, maybe from Mr. Alocher's petition, was, would we be giving immunity to the president for violations of the Constitution? Would we allow a president to continue violating the Constitution and only be able to sue him if he's outside of office? And this option, as has been exercised in the past, that his decisions can still be challenged, means that we can continue to hold the president to account through the avenues given to us under Articles 222 and 258 of the Constitution.
Great. Thank you, Christine. That's a good summary. I'm going to put the same question to Dr. Abebe. Please, may you give us your views on presidential immunity with particular reference to how it was addressed in the Supreme Court judgment. Thank you.
Thank you very much. And thank you very much also for Christina for making my life very easy. I think I won't go back to the details, as she's given us an extremely good summary of the background to the case and how the judges in the Supreme Court handled the issue. What I would say is that I think the challenge reflects the fact that constitutional design and its sibling constitutional interpretation often involves a trade-off between fundamental values that we all hold dear. And I think immunity is one of those issues. And what I tried to do right after I got the agenda was try and check in other places how other countries deal with the issue. And from my quick research, I found that the Kenyan constitutional provision and the way it was interpreted by the courts as not unusual. It is quite common. And in fact, the drafters of the Kenyan constitution have gone a bit further to create exceptions, particularly in relation to criminal immunity from criminal proceedings. If you compare the provisions with, for instance, countries like Ghana and Botswana, which are seen as at a level with Kenya, let's say, in terms of their democratic dispensation, you will see that the Kenyan provision is actually quite robust. So in that sense, I think it's not just unusual, but also I don't think it was unreasonable in terms of their reasoning and the final outcome. And I think the most important thing, and I think Christina touched on it, is that this is not immunity against the president in the sense that his decisions cannot be challenged. His decisions can be challenged, and if those decisions, if the challenge results in a particular order, the president is bound to follow them, right? And so it's really whether he is named in his own person in a particular proceeding, but he's bound by law, he's bound by judicial proceedings and their outcomes, and he's bound to comply with those. And even in cases, even personally, what the Constitution does is essentially defer the time within which the presidency may be sued, and sometimes deferral of those proceedings may be too much, especially if a particular decision is seen as manifestly in violation of the Constitution or other fundamental ideas that can, of course, lead to a sense of lack of equality before the law and undermine broadly the legitimacy of the state, which could lead to conflict and other things. But the Constitution also has possibilities. So whenever something is seen as too egregious, too big, of course, there is the impeachment procedure. And of course, especially when a president has to run again, we can consider democratic elections as one ways of ensuring that the president actually takes into account seriously the constitutional provisions. Broadly, I find the normative standards in the Constitution quite common, not unusual from comparative perspective. I also find the interpretation of the courts reasonable. We can always agree where it could be sharpened, but I think overall the reasoning and the final outcome was also acceptable. And in cases where immunity can be said to undermine the fabric of the constitutional framework, there are ways out of those circumstances to make sure that those violations do not undermine the legitimacy and workings of the broader framework. So I'll stop there. Thank you.
Thank you, Doctor.
Thank you very much, Dr. Adam, and thank you, Christine, for shedding light on the question of presidential immunity. I want to pause there for just a second and say to our audience that you can follow this discourse also on social media by tagging the respective handles at ICJ Kenya, at Katiba Institute at CAS Kenya, and at the Avid Readers Forum of Kabarak. This discourse is also taking place live on the ICJ Kenya YouTube platform, as well as the Kabarak Avid Readers Facebook platform. So you can also engage on social media. There's also the chat function and the question and answer function within the Zoom setting. So please do put your questions to the panelists in the chat section. And when the time comes for question and answer, we will call on you. And if you need to vocalize and voice your question to the panelists, that is also an option that is available. So we will call on you at the right time. So I want to quickly change the discourse to a 5-minute perspective on the very pertinent question of public participation. What is effective public participation? What is the constitutional threshold? When can it be ignored? And I think the best people to answer this question are Dr. Gautam Bhatia and my colleague here, Mr. Dudley Oching. So I'll start with Dudley at the studio. What is the constitutional threshold on public participation in 5 minutes?
Well, after the Supreme Court judgment, I've been left confused on the issue of public participation. I say so because the Chief Justice in a judgment says that the 4 sequential steps, which 4 sequential steps? Public participation, civic education, constituent assembly, and referendum have no legal basis in constitutional amendment. Well, she's contradicted by Justice Lenaola, who says that it would be unheard of to say that the people have no role in constitutional amendment, though he still finds that basic structure doctrine does not apply and those 4 steps are irrelevant to constitutional amendment. Same for Justice Mwilu, who finds that the 4 steps are inapplicable. What are those 4 steps? Public participation, civic education, referendum, constituent assembly. It's so confusing that the Supreme Court of Kenya can hold that when you want to amend the constitution, civic education is inapplicable, public participation is inapplicable, and the Constituent Assembly, that's a different debate altogether. But the issue of public participation is at the heart of the Constitution. It was made through deep, ingrained public participation. It can only be changed or amended through the same process. And what's funny is that the court says that these 4 steps do not apply when those 4 steps are found in the tiered arrangement that the court endorses. Public participation is expressly found there. So when the court says that these 4 steps are inapplicable in Kenya, I do not understand that. It has left me confused on the place of public participation in constitutional amendment. But what is it? It is engagement with the people, recognizing, as the Supreme Court has previously told us, that the Kenyan population is adult. It can decide for itself. So it is a good faith engagement with the people, an exchange of ideas, so that the decision is informed by views taken from the people. It is not an exercise in public relations. And in constitutional amendment, we've seen it before. The copies of the previous constitution, when it was in draft, were taken down to the village level. They were supplied in Swahili. Funnily, the current constitution has not been translated into Swahili yet. I hope that will happen at some point. But the idea is that the previous constitution, the current constitution, when it was being made, we had deep public participation occurring. I received the copies in my local church on a Sabbath afternoon. That did not happen with this BBI bill. And I think the majority were right in saying that there wasn't sufficient public participation on the bill. Thank you so much, Julie.
Thank you so much, Dudley. A mixed view on what the court said on public participation. I'd like to ask Dr. Gautam Bhatia, who's a constitutional lawyer, to chime in on the Supreme Court's take on public participation.
Yeah, thank you. So I think a couple of things. One is that it's really important to note that the scheme of Articles 255 to 257 has this balance between representative democracy, that is amendments to the parliamentary route under Article 256, and direct democracy, which is amendments to the PI under Article 257. And the latter necessarily assumes a very high degree of public participation. And in fact, the court's finding that the president cannot initiate a PI really chimes in with that understanding that the amendment process under the PI has to be bottoms up, driven by the people, and that's where this element comes in. So I think that there are three things that I take away from the Supreme Court's judgments, of the opinions that make the judgment. One is that when the Supreme Court says that the tiered amendment process under Articles 255 to 257, its purpose is to provide an internal constitutional safeguard against hyper amendments and against abusive amendments. So one way that internal safeguard is provided is through a heightened level of public participation. And that happens at 4 different stages under Article 257. So once the Supreme Court has opined that the purpose of this tiered process is to have an internal safeguard against abusive amendments, it must follow then that the scope of public participation in these provisions has to be given its full extent, because otherwise you can't really have an internal safeguard if you water down public participation. That leads me to my second takeaway from the judgment. And in my reading, a majority of 4 judges hold that the burden of proof in a dispute over whether adequate public participation has happened or not lies upon the state. So given that the state organs are the ones who have to conduct public participation in 3 of the 4 steps, the burden of proof lies upon the state organs, and the state organs actually have to show using evidence that a level of public participation that actually is sufficient to provide that internal safeguard against abusive amendments actually has happened in this case. And that, of course, following from various Kenyan precedents, involves the time period you give for public participation, the distribution that you do, and things like that. One thing I thought was perhaps somewhat lacking in the Supreme Court judgment was at the High Court and the Court of Appeal level, there was detailed analysis of things, for example, like the only copies are on the internet and how much of the Kenyan public has access to the internet. So all of those things really played a part in the judges, the Superior Courts, High Court and Court of Appeal reaching the finding of no public participation. That I think was perhaps somewhat missing in the Supreme Court's various opinions. And the third and final takeaway that I have from these opinions is that in Article 257, it's a process, and there are 4 different steps, and the amount of public participation that has to happen depends upon the steps in question. So for example, at the first step, when you have the promoters, if the promoters are, say, ordinary people who don't have the backing of state organs, then obviously the resources that they have to conduct public participation will be limited. So at the first step, you have perhaps a somewhat less onerous requirement of public participation. And as you go down the road through the steps, the responsibility of public participation increases the final referendum step of voter education, where it's at its highest level. So I think that's an interesting reading of the sequence through which the 257 process goes. And a corollary of that is that, as the court rightly points out, ultimately the details of that have to be worked out by legislation. So until a law exists, of course, the court can fill in the gaps. But that fine-grained understanding of what exactly public participation requires at each step has to be done by statute, of course, subject to judicial review of whether it's adequate or not.
Issues that have generated a lot of discussion and controversy. Thank you.
That has also left me very much confused because of these reasons. According to the Supreme Court of Kenya, the IBC's quorum is 3 because its composition, the constitution says could either be 3 up to 9 members. The legislation gives it 7 because the constitution says each commission will have between 3 and 9 members. It doesn't happen by chance. Parliament deliberately looks at each commission and determines a quorum for it depending on that commission's function. Now, the parliament has given IBC a quorum of a composition of 7 members. And legislation had said that out of these 7, the quorum would be 5. But the Supreme Court now says that in fact, IBC is competently composed if it has 3 members. My apologies. I hope I'm audible now. Thank you so much. According to the Constitution, each constitutional commission can have between 3 to 9 members. The IBC has 7 members, and the legislation had set its quorum at 5. And then there was a dispute around the 2017 presidential election. There was a split in the commission, a 4-3 split on how the presidential election was being conducted. So Parliament amended that quorum to 3. The court invalidated that, saying that because of the functions of the IBC, the quorum should be 5. Now the Supreme Court has gone a step further. It has said that in fact, IBC does not need the extra 4 members, that it's competently composed if it has 3 members. When you have a commission composed of 3 members, the majority of those 3 is 2. So today, a decision at the IBC can be made when 3 members are present and 2 of them decide. 2 out of 7, according to the Supreme Court. That has taken me to the Judicial Service Commission because that is the one closest to the judiciary. It has about 11 members. 2 of those members are lay persons appointed by the president. The third one is the Attorney General. So today, the JSC is competently composed if it has 3 members present, the Attorney General and the 2 lay persons appointed by the president. 2 of those, the 2 lay persons, are enough to hire the Chief Justice or to fire her, according to the Supreme Court of Kenya.
Thank you, Dudley. You've left us with the question still standing. But we'll move on to the... Oh, sorry, Julie, do you want to go ahead?
Actually, it's very interesting because we're going to pose another question to Dudley. We're coming back to you with the question on referendum. I know that from your analysis, there's a lot that the court split on. But the question in the referendum was also another question that they more or less seemed to agree on. But I'd want you to chime in a bit about that. What do they mean when they say some issues are ripe for discussion, some issues are not? So the referendum question and the issue around framing and presentation of questions.
On the 1st of March, the first was the first time the Supreme Court was unanimous on the question of referendum. Last year, 16th of March, the court was unanimous finally that it should wait for the referendum question to rise up because it had been raised in a very straightforward in a matter where the Supreme
Dudley, unfortunately, I have to stop you once again. The mic is having a challenge. I'll pass you mine.
I don't know who's sabotaging my speech today. Well, that first March wasn't the first time the Supreme Court was unanimous on the question of referendum. Last year, March, the 16th of March, Ongoya and myself appeared at the Supreme Court in two advisory references filed by the county government of the County Assembly of Nandi and Kericho and the governor of Makueni, state organs who have duties on referendum or constitutional amendment and who needed the clarity of the Supreme Court. 5-0, the Supreme Court decided that it would wait for the referendum question to come up to it. Why? Because the same issues presented to the Supreme Court had been raised in the 7 petitions pending at the High Court. So the Supreme Court says we have jurisdiction, but we are deferring it. We will wait for this matter to rise up to it. The matter rises up to the Supreme Court. And again, the Supreme Court now 7-0 says that this issue has never been ripe for judicial determination. Another confusing aspect of that judgment. How could it not be ripe for judicial determination when the next step, going to the referendum, had only been stopped by a conservatory order given by the High Court? How could it not ever be ripe for determination when the Constitution says in very clear terms that one does not have to wait for an action to crystallize? In other words, threats are sufficient to invoke the High Court's jurisdiction. The Chief Justice says that one must wait for an action to be taken against them before they can come to court. You must wait to be tortured before you can come to court. You must wait before you are killed before you can come to court. Threats do not suffice, according to the new jurisprudence from the Supreme Court of Kenya.
All right, before I invite Prof. Sihanya, I want to pass the mic to Mr. Elisha Ongoya on this particular issue. You have been named that you are part of the team that was before the court, so maybe you can chime in a little bit, and then thereafter we'll pivot back to Christine on a clarification on an issue that was made earlier.
Thank you so much, Julie, for that. In my other capacity as a litigation counsel, it is true that I was instructed by the county assemblies of Nandi and Kericho to go and seek an advisory opinion on certain specified questions. One of the questions we posed to the Supreme Court was the question of the principle that has now culminated into the name unity of content in framing referendum questions. That can you present an omnibus bill dealing with multiple completely unrelated matters to the voters, or do you present distinct separate questions to the voters, or do you isolate related matters into distinct questions so that you pick a group of questions relating to a particular matter? Say, if the bill has questions that touch on the independence of the judiciary, you present questions around that. Then you present questions around, say, presidential immunity or presidential term of office. Then you pick other questions so that there's unity of content in the matters you present to the voters. And the reason why we presented this option of unity of content was because of something called consequential amendments. That once you make one amendment, it may become inevitable to make another. So you may need to present those as united themes for determination. The Supreme Court took us through a laborious exercise to serve those proceedings. We served. To prepare submissions on the entire opinion, we prepared submissions on the entire. In fact, I've jumped one step. It told us, go to the Attorney General first and seek the Attorney General's opinion on this question before you come here. We had to hold the advisory opinion in abeyance to go to the Attorney General, got an opinion from the Attorney General, declared that opinion unsatisfactory, then resubmit ourselves to the Supreme Court advisory opinion. So once we had finished all the filings, just pending the usual 5 minutes we are normally given to highlight the submissions, the Supreme Court came with a ruling that indeed we have jurisdiction. But we are going to decline to exercise this jurisdiction because another court has been moved to determine that matter. We will wait for that court to determine that matter, and that matter will be processed through the judicial system properly until it reaches the Supreme Court. Credit to the state of Kenya, and I'm very happy with the state this time around, because the state took up the burden of meeting the logistical costs of filing the appeals, which were not mild in terms of records, until the matters reached the Supreme Court. When we said, and I mentioned this question when I was opening my submission to the Supreme Court, that we were here, you told us, hold your horses. We have come back. Now pronounce yourselves this question. The Supreme Court told us, no, this matter is not mature. It is still a fruit that is green. Wait until you see it yellowing, then come here. But there's something very puzzling. I trust I'm not misquoting. If you read the judgment of Justice Joaquin Dungu, she actually found the matter was not ripe, but again found that to her, it is the complete bill. And that was extremely puzzling. I mean, you are saying it's not ripe, then you are pronouncing yourself on it. That, to be honest with you, will take me a number of years to come to terms with and to understand it. And those are my thoughts on that subject.
Thank you very much, Mr. Ongoya. Thank you very much, Dudley. I think that this particular question is something that will be center focus of a lot of lawyers, a lot of civil society, because referendum, public participation are questions that we cannot run away from. I think we have just been given more push to further this discourse and bring people to the table so that we can find a way forward in regards to these two issues. Now, Christine, I think there's a slight thing you wanted to clarify around your presentation earlier on IEBC.
It's actually not on IBC. Actually, yeah, it's on IBC. That is the quorum of the IBC. And maybe I needed to lay a bit of context to what Dudley has said, because how the question came up from the High Court and had come on from the petition of Muhuri is at that time, because certain IBC commissioners had resigned and the vacancies had not been filled, and there were essentially 3 in number, is whether they could have transacted the business of receiving the signatures, verifying the signatures, and actually transmitting. After that verification, after ascertaining it meets the threshold, now passing on that bill to the different county assemblies for processing. And at the background of this was 2 court decisions. There was the decision that Allah said that with a quorum of 3, the IBC could continue transacting, but for by-election purposes and other items that were not to be policy issues, as had been clarified by the decision in the Katiba Institute case that said for policy issues, the full number of commissioners was needed, and that is the full, the 5 as a quorum and 7 as a composition. So here is a bit of the legal challenge or to understand the consequences of what happens, and I'll give my interpretation for it. There is a law that provides under the IBC Act that is not challenged, that has not been declared as unconstitutional, that provides the membership of IBC as 7 and quorum has 5. The unconstitutionality of that law, that section, was not an issue that was addressed at the High Court, the Court of Appeal, and therefore not a question that came up for determination at the Supreme Court. So the idea is, as the decision of the Supreme Court rendered that provision unconstitutional, has it by effect repealed that section of the IBC Act to mean, that actually the composition should be 3 and therefore quorum 3. Because they have equated, as I read it, quorum and composition to be the same thing. But for me, I would say that would be an absurd reading of the law, because there definitely needs to be certainty of law. And we know how laws are repealed or amended, either by parliamentary fiat or through a judgment of the court. But for a court to declare a law unconstitutional, that law must have been purely, centrally the issue of determination. So I see this as actually obiter in the sense that if right now the quorum of IBC remains 5, composition remains 5, and the quorum remains, the composition remains 7 and the quorum remains 5. But the effect of the Supreme Court decision is if Parliament should at some point amend the law and provide for composition as 3 and quorum as 3, then that would not fly against the constitutional provisions. So right now, I would say the effect is that the law remains as it is, because what would happen right now, IBC is fully quorate and fully composed in membership of 7. So that still remains the law. It hasn't been declared unconstitutional. It is looking into the future if Parliament should amend the law and provide for a composition of 3, then there's sanction or approval of that action by the Supreme Court.
All right. Thank you very much, Christine. I want us to turn to our last panelist on the studio, Mr. Prof. Bensi Hanya. And I'll ask you 2 questions. And appreciating that Professor Nixon is in Australia and time is running out, she should be leaving the Zoom anytime now. I'll ask that we quickly address 2 issues before we enter into the meat of the conference, which is basic structure doctrine. So I'll ask 2 questions, which is, 1, the amendment of the Constitution by popular initiative was something that was discussed at length. But the bigger question was, what is the place of the president in regards to popular initiative? And the second question that I want you to address is the creation of the constituencies and the manner in which they were created. Whose role was it? Was there a violation in the process? And has this decision clarified whose mandate it is to create constituencies in this country? So I'll ask you to address those 2 questions, and then now thereafter, we can now go into the basic structure doctrine discourse. Thank you.
Good afternoon, all panelists, all participants, wherever you are located or wherever you are based. I think I want to file first a preliminary objection on the structure of debate, and with a smile, of course, that the structure of this debate has been that in Kenya, there are largely 2 broad perspectives to this debate. There may be a third one, but there are largely two perspectives. And my three-pronged preliminary objection is this, that the composition of the panel, whether online or physical, how have they expressed their views on these issues? I don't take it too badly, but because we can debate even 1 against 1,000. Number 2 is a question about this us versus them, heroes versus villains. I addressed this in the past debate when we were here. I want us to say all of us are seeking to construct a good Kenya, a progressive constitutional democracy. Some of us have a stellar record on independence of the judiciary, which I don't boast about. Its record is there in the academy, in the bar, etc., etc. So an us versus them, I don't know whether that can be called intellectual blackmail or whatever it is, and let us avoid those heroes and villains in this debate. And lastly, for me, on this preliminary objection is also the order of presentation. I think I liked that last time when we had this idea that a briefing, even with 3 minutes, prefacing what is likely to come, so that the audience can also follow what will come. I leave it there, and then I address the specific questions that you posed to me. You posed to me the 2 questions regarding the role of the president, yes, in the amendment process, especially through the popular initiative. I want to start by saying that the Supreme Court got the constitutional interpretative, what I call constitutional interpretative methodology, quite right. That is what had been missing in the High Court and the Court of Appeal. And as we always say, if you get the questions wrong, you can't get the answer right. And the question has always been, the beginning point is constitutional interpretative methodology. And the Supreme Court got it. What we have been saying is text, structure, history. We can repeat that 1,000,000 times. If you get it otherwise, you can't get the answer right. You start with what does the text say? Literal, ordinary, Nairobi, Kibera line is Sabah meaning. Before you can go to any detailed debates about that. Then you go to the question of structure. Structure in the sense of how the control is organized and how the provisions relate one vis-a-vis another provision. For example, there's always an argument that what comes first is regarded as more important as opposed to what comes second. Of course, there's also an exception that sometimes what comes second can be more important. And that's why the constitution is structured. The constitution is structured in a way that issues about the republic, issues about the people, issues about representation, issues about representation come and the people come in a way before you deal with the issues of the executive, among others. Then to answer this more directly, and then the history and process. History, precedent are also very, very important, but a holistic reading of the history. But having said that, that the Supreme Court got the methodology right, it is my considered opinion that only Justice Njokindungu used that methodology in analyzing the question that you have given me, the question of the role of the president. It's only Justice Njokindungu who took trouble to say what are the relevant constitutional textual references on the role of the president. The other judges, at least in the summary, they mainly used logic. Logic is important, but not the primary reference point in constitutional interpretation. So what does Justice Njokindungu say, which we many have argued before and I still upload, that look, who is the president? The president is primarily a person who enjoys Article 38 political rights. There's no exception in the text to the political rights of the president. The president, there's also Article 1, sovereignty of the people, which can be exercised. And the amendment of the constitution is an exercise in popular sovereignty. And I would say that the basic structure doctrine is dead when we'll come back to it. Long live popular sovereignty. Long live the ability of Kenyans to debate the constitution without having to seek permission from Dr. David D, from the judge, any judge, or from Professor Rosner and others who have written on this, but not specifically on Kenya. So the president, therefore, has a role in so many ways in amendment of the constitution, and because there's no exclusion, would have. What that means is that, for example, even if you want to go to logic, let's even now go to logic because there's no textual reference barring the president from participation. The main issue in Articles 255 to 257 is a question on terms of popular initiative. It's not so much the initiative, the focus is on the promoter. That's when you start having concrete provisions. Who is a promoter? How does the promoter come in? How do they relate with IEBC, etc., etc.? And therefore, the court ought to have focused attention on who is a promoter and who was the promoter. And I'm glad that Justice Njokindungu and Justice Lenaola helped advance that issue quite a bit. And there's also another judge who also said that we see the president can actually, even under Article 38, the president can even campaign for amendment because the president would enjoy Article 38 rights. At least another judge said that. But if you block the president from this process, these are some of the three consequences moving forward. Number one, the president doesn't sit in any of the three houses, doesn't sit in the county assembly, doesn't sit in the National Assembly, doesn't sit in the Senate, and have no direct access to those houses. Either still properly working control system of Kenya, they have no access. So which means that they're blocked out even from the parliamentary amendment process that we were being told that the president can participate in. Number two, and probably this is even more fundamental, the president is supposed to be elected, and therefore can exercise popular, so can be part of the exercise of popular sovereignty, because we can exercise it directly or through elected representatives. Lastly, is that on this issue is that the president may be a very popularly elected, a very popular president, popular with the voters, even earning genuine 99% of the votes, genuine, credible, under Article 81, 86, etc., etc. Not the way it's earned in many African countries, but genuine. But that the president may not have the seats in the House, in Parliament, which means that that president would be a hamstrung president, would be a president who cannot do much using the House that we are being told the president can use. But then the people would be expecting something from the president, especially in a Kenya now that requires cultural reform to help fix tribalism, help fix exclusion, help fix corruption and economic decay. So how would the president be expected to operate? Let me just go to the second issue which you asked me about, constituencies. The constituencies issue, again, unfortunately, the court again did not apply the constitutional interpretative methodology that they had clearly applied in the other 5 questions. What do I mean? Number one, tricky issues, because I'm always inspired by a 3-pronged approach, the Holy Trinity, etc. 3 issues about this. Number one is that if you amend a constitution through a popular initiative, you can amend any clause of the constitution as we speak now. You can actually even amend the amendment formula in Articles 255, 250. You can amend it through popular initiative. So how can we say, how can the same court say, yes, there is no basic structure doctrine, there's no eternity clause, there's no unamendable clause, but you cannot touch the role of IEBC in the constitution? We were doing it, this was being done through a popular initiative, which can attach anything. And therefore you can even say, actually, theoretically, you can abolish IEBC through a popular amendment. Actually, you can do that. So that was really was not, I couldn't get it. I didn't understand what they meant. But then secondly is that here there's a big question. There's a big question on, there was also a question about schedule. How can you put on a schedule and something that is so substantive? I think that came from Justice Njoki Ndung'u. And my reading of the constitution is that the Constitution of Kenya 2010 has 6 schedules. And those 6 schedules have been used to write laws in this country, substantive matters. We have used those schedules to do judges and magistrate vetting board. We have used those schedules on so many issues. Actually, the power of the balance of power between the national government and county government is in a 4th schedule. So the fact that you are calling it a schedule, whether of a constitution or a statute, does not make it any less. In fact, I think that the understanding is that it is fundamental part of that law. So I think, let me say that, I think you were saying that whose role is it to work on these issues of moving forward? Primarily, as it is, IEBC has the role, but if Kenyans want to change the number of constituencies, the boundaries, their names in a referendum, it can be done. Inawezekana. The people in a referendum can do that. But as of now, if there is no amendment, that is the role of IEBC through a participatory consultative process. Thank you.
That we have. I see that we have quite a lot of questions in the chat section, and also from our social media sites. We can see that people are raising their views on this issue, and I'm sure we will get quite a lot of feedback, particularly on the last submissions by Professor Sihanya. But now I wish to invite Valentine to take us through the basic structure doctrine questions, particularly because we have a few of our panelists who are in a whole different time zone. So let's hear them before they have to drop off. Over to you, Valentine.
Thank you. And good afternoon, Professor Dixon. We request that you share your views on the basic structure doctrine and how it was addressed by the Supreme Court, please. Thank you.
Thank you so much, Valentine. Can you hear me? I just
Yes, we
want to
hear you.
begin by saying what a privilege it is to be joining you in Nairobi as a global scholar. One of the things that I have found so impressive about learning about your process is how unbelievably seriously the Kenyan courts took all of the arguments they received, not just from Kenyan lawyers and parties, but from a range of amici around the world, including people like Adem and Gautam and myself. And it was a privilege to be part of the proceedings. We were also lucky to be able to watch a number of the arguments because they were televised in the nature of the proceedings. And I think whatever side you come down on in this political dispute, I think one can have great pride as a Kenyan in the way in which the judicial system has functioned. And that even through COVID and, you know, challenging circumstances where argument had to be conducted in marquees or tents, where things were really difficult, the quality of the argument and the seriousness that the court gave in terms of a hearing was really, I think, so impressive. And so I think that one of the things I wanted just to note is that it's a privilege as a global scholar to be part of this conversation today, but also to have had a role in the courts, but most important, to have observed Kenyan democracy working so well in the context of commitments to the Constitution and the rule of law. Second thing I want to say is that I think that the quality of the decisions of the various courts is very high, and that whatever view we take, I think we can say that both the Supreme Court on the one hand and the Court of Appeal and the High Court on the other reasoned in a persuasive and thorough way that is respect-worthy. And so that the competing views on this question, I think, are reasonable and well-reasoned, and in ways that again underscore a basis for confidence in the judiciary and the rule of law in Kenya, at least as it is being upheld and practiced by the bar and the courts. There's two basic positions, as I understand it, on the basic structure doctrine. One is that the written provisions in Articles 255, 256 and 257 of the Kenyan Constitution create what David Landau and I have called a tiered amendment structure, different levels of amendment difficulty that reflect a trade-off between the drafters, between the virtues of amendment flexibility and rigidity, and that it is exclusively a tiered structure provided for by the Constitution. That is one view. The second view is that Articles 255 through 57 represent a general endorsement of the idea of tiering that creates, if you like, a floor on what is required to pass very serious constitutional change, not a ceiling, and that it is appropriate for courts to imply additional hurdles that are substantive and procedural in nature in order to protect what the Indian Supreme Court in that very famous decision, Kesavananda, called the basic structure, and which the High Court and the Court of Appeal endorsed. I think both of those approaches are legally plausible and respect-worthy. And of course, the Supreme Court preferred the first view, that the tiered structure of the Constitution is exclusive as regards amendment limitations, whereas the Court of Appeal and the High Court took the latter view. And a number of us intervened in support of the High Court and the Court of Appeal. And to that extent, I preferred their approach. But I do think the Supreme Court's approach is legally plausible and well-reasoned. And I think it is a totally available interpretation as a matter of orthodoxy. So what do we want to make then of the fact that the court preferred the view of tiering, formal tiering as exhaustive? I want to say three brief things, if I may. The first is that in global terms, we often talk about the unconstitutional amendment doctrine as having both a procedural and a substantive dimension. And the Supreme Court ruled out the substantive dimension to an unconstitutional amendment doctrine in a certain kind of sense, but they did uphold the procedural dimension, including by virtue of the emphasis on the ways in which amendments can be proposed and the limit in this instance on the President's power to propose amendments outside the terms of Articles 255 to 257. So it is in some sense an endorsement of a procedural unconstitutional amendment doctrine in ways that are to be celebrated and noted as an important limit on the power of amendment if one takes that idea to be desirable, as I do. The second is that one could read the Supreme Court as reverting, as our previous panelist has suggested, to a slightly more orthodox legalist approach that emphasises text and history over broader structural commitments to democracy and the sort of structural origins rather than the specific debates around amendment of the Kenyan Constitution. It could be regarded as a move from a more purposive, teleological or functionalist view of the Kenyan Constitution to a more textualist or orthodox legal approach. And I think that is in some ways what has happened as between the High Court and the Court of Appeal and the Supreme Court level, and in some ways represents the duality in Kenyan constitutional and legal culture, which I think is very common to many common law countries in the Anglo-American world, particularly those like Kenya and Australia, influenced by the British tradition. You have a purposive teleological break, what Gautam and others might call a transformative constitution, and yet it is superimposed on a very legalist, fairly orthodox tradition of argument and judging. And there is always going to be a tension in countries like Kenya. Indeed, countries like Australia, Ghana, India, you name it, between, if you like, the purposive and the transformative and the more orthodox legalist and preservative. And I think that is evident in this reasoning. But in my view, the more likely explanation is one that one has to put somewhat delicately, but I think is important to note. This was a very difficult decision for the Kenyan judiciary politically, and one needs to see the decision in its broader political context. As other panelists have noted, the funding decisions announced this week in relation to the judiciary, I think, underscore a very fragile and delicate position in which the judiciary finds itself. If it does not stand up for the basic constitutional structure, it is risking an erosion of that structure in ways that undermine constitutionalism and the rule of law. And yet, if it is too rigid in an insistence on a particular constitutional vision that is not in accord with the president and the president's supporters' vision, the court risks its own position and its own budget and strength and independence and autonomy. And in that view, one could see the Supreme Court here as threading the needle, trying to insist that the original constitutional framework does apply and must be complied with, in the sense that the procedures for proposing amendments need to be in accord with the original constitutional design, and imposing a limit here on the president and his ability to go outside that framework, standing up in a very powerful way for the rule of law and the constitutional design that is so powerful coming out of 2010. On the other hand, the court has provided some degree of leeway for the government to come back and reintroduce amendments of the BBI kind, should they wish to do so, through the proper format and through increased consultation and procedures as provided by the Constitution. By doing that, they create a safety valve that allows for a response to the court that is one of disagreement, but not one that involves destruction of the courts and judicial independence. So that while for my own part, I would have been supportive of the courts implying a basic structure doctrine in Kenya, I think it was legally open to the Supreme Court to take a different view, and time will tell. And I think it's ultimately for the Kenyans in the room to decide, not for global scholars. It is possible that the court has threaded the needle in a way that creates a pragmatic accommodation of the political challenge in which it finds itself, but a principled commitment to upholding the original constitutional design. And I'm mindful here of examples that I've written about and that I've written about with Professor Sam Zakharov at the NYU Law School about what we call deferral in defense of democracy, or courts living to fight another day. There's no point in courts announcing very robust doctrines, which are then an immediate provocation to government actors to attack the courts. And that has been the case in India, in Colombia, in many other countries. And I would welcome people's thoughts and reflections on whether, even though people who advocated the basic structure doctrine may be somewhat disappointed in the reasoning, whether there is a degree to which the court has managed to thread the needle between pragmatism and principle in a way that is praiseworthy. Perhaps I overread it from afar, and I look forward to being corrected by those closer to developments on the ground. But as I said, even though I intervened as an amici to support the Court of Appeal position, I think it is both a sign of the maturity and depth of the rule of law in Kenya that this level of argumentation was produced both by advocates and the court, number one. Number two, that both positions are legally arguable and that they may reflect simply a recalibration between more purposive and textualist or legalist approaches. And number three, that another way of reading the recalibration is in more contextual, pragmatic terms, which are regrettable but necessary in a situation of this kind, and where one might have other reasons for thinking that the Supreme Court's decision was wise. So thank you for the opportunity.
Thank you, Professor Dixon.
Thank you, Professor Dixon. We would like to invite Dr. Gautam Bhatia to also share his perspectives on the basic structure doctrine and its applicability in Kenya. I note the commentary around pragmatism versus principle, and I think that was one of the few things that came up even in the discussion around the basic structure doctrine in Kenya. So I'd like to hear your thoughts on this particular doctrine and its applicability and what the Supreme Court did say as regards its applicability in Kenya. Thank you.
Thank you. I think Professor Dixon really covered a lot of that ground, and really well. And to that extent, I completely agree with her assessment of that very difficult balance that courts have to strike between sticking to principle and writing judgments that do not end up undermining their own ability to continue doing that, in the times to come. But I think on the technicalities of the judgments themselves, it strikes me that there is a bit of a gap between what the disposition of the court is in the final orders and what actually emerges from a reading of all the 7 opinions. So, the disposition is that the basic structure doctrine is inapplicable in the Kenyan constitutional context, and the 4-step sequential process is not required in the Kenyan constitutional context, which would appear to imply that insofar as the basic structure doctrine, broken down into simpler terms, is the ability of a court to judicially review a constitutional amendment for compliance with the Constitution's basic structure. That ability, the Supreme Court has said, does not lie with the judiciary in Kenya. But if you actually read the 7 opinions, there seems to be the situation becomes a little more complex, because while Ibrahim J is formally in dissent on this point, and he agrees with the High Court and the Court of Appeal's majority in all respects on the basic structure issue, Dr. Smokin Wanjara J holds, in his opinion, that insofar as there is an attempt at constitutional subversion, then the courts will not sit back and watch helplessly. And in some ways, the basic structure doctrine actually does pretty much say the same thing. It says that when an amendment effectively amounts to constitutional subversion and is not simply an amendment, formally speaking, that's when the doctrine kicks in. And then he goes on to say that he does not think that this particular case was one of those seismic moments, thus implying that if there was a seismic moment, then you would be applying something like the basic structure doctrine, even though you don't call it that. Similarly, in Justice Muliu's opinion as well, she seems to indicate that when it comes to this kind of a seismic change, then it does call for the primary constituent power to kick in. And in fact, when she actually strikes down the schedule, one of the reasons for striking it down is that it's not in harmony with how the Constitution deals with allocation of constituencies in the role of the IABC, which again is a very basic structure kind of reasoning, because one of the crucial elements of the basic doctrine is that an amendment is no longer an amendment when it's in fundamental disharmony with the Constitution's material core. The old analogy of the house, like you don't tear down the house, you can add things to it. So you see that not one but at least three of the learned justices, even though they don't call it basic structure, engage in what seems to be something like basic structure review, which they hold that in this case doesn't apply because the amendments in question in the BBI bill don't reach that level of constitutional subversion. So that's 3 out of 7. Two more, Lanola J and Aukuje, also seem to draw a distinction between a constitutional amendment and a fundamental constitutional alteration as a conceptual distinction between the two. And they don't complete. They of course don't specifically hold that if the latter was the case, then you would apply substantive review. But there are hints in those two opinions as well. And finally, in the Chief Justice's opinion, there's a continuous reference to amendment, and the Chief Justice, she says that the basic doctrine doesn't apply to amendments under the Constitution, which again is interesting because the basic structure doctrine basically says that when you have an amendment, then of course it doesn't apply. The normal processes apply. It only kicks in when an amendment is no longer an amendment; it's a fundamental alteration, and that there is a conceptual distinction between an amendment and a fundamental alteration. And it's only in the latter cases when you have something like the basic structure doctrine applying. So again, that question then is left open in the Chief Justice's opinion. And so I think there's only one judge who categorically rejects out of 7 altogether any possibility of the application of substantive judicial review over amendments that go beyond simply amending and actually seek to achieve a fundamental alteration. So in my reading, and of course subject to correction, I think that although in formal terms, the Supreme Court admittedly has rejected the applicability of the basic structure doctrine in the Kenyan constitutional context, because that's what the order says. The question in a future case, if someone was to point to a specific proposed amendment and say that this amendment is not actually an amendment, but seeks to destroy the Constitution's material core, say for example, just to, for example, take an Indian example, there was a case where Parliament amended the Constitution and basically made any judicial review of a fundamental rights violation non-justiciable, non-reviewable, as long as the law just stated that it was pursuing a socially required goal. So if basically the law stated that this law is pursuing a socially required goal, the court could not review it on fundamental rights grounds. That basically took away the fundamental rights chapter altogether. It made it redundant. And the Supreme Court said, that you can't do that. So say an amendment of that kind, which effectively makes the entire Bill of Rights redundant by taking it outside the ambit of judicial review was to be passed, which did happen in India. And a petitioner, say in Kenya, was to say that this is not an amendment. It actually destroys the core of the Constitution, or in Smoking Manjara Raj's view, it's a seismic constitutional moment. Any of those terms that are used. I think it's actually the petitioner would have a case that the Supreme Court judgment doesn't, by a majority, cover that point, leaving it somewhat open. I think there's a bit of a tension in, I think, the judgments as a whole, and the question is perhaps a little more open than what seems from the order. But of course, how it plays out in the future would depend on, the amendment in question, the High Court that hears it, and all of that. So I think it's a little open yet, this whole issue. It's just not called the basic structure anymore. That has been turned down. But that the courts can review sweeping alterations or destructive to a constitution, I think that question is still open.
Thank you, Dr. Bhatia. Thank you. So now we're going to go to Professor Sihanya and ask for his views on the basic structure doctrine. Professor.
Thank you so much. So the basic structure doctrine and its close relatives are, one is structure, two is basic structure, three is basic structure doctrine. And these issues were conflated in the High Court and Court of Appeal. Conflated, used as if sometimes they were used as if they are interchangeable, and sometimes used as if they were mandatory, as if some text, constitutional text ordained them, or structure or history ordained them, or as if some international law or established general rule or general principles of international law have ordained them. And that's where the problem began. Earlier on, I said that every constitution has some structure, but I'm also saying that that structure is not something that's mandatory, that it must have that structure. Neither at national law or in international law is there a mandatory structure of a constitution. There may be issues which are mandatory in content under International Bill of Rights, Universal Declaration of Human Rights, and the Twin Covenants. But in terms of structure, that this is how you must write your constitution, and these are some of the how they should follow each other, and this is how you can't amend or can amend, is not there. And that, I think, helps us dispose of that issue partly. The other issue, so the question is, what is basic structure doctrine? How do we conceptualize it? What is the proper appropriate nomenclature? How do we identify one when it exists, if at all, and what are the consequences? I think this was largely an academic debate, and I'm glad that Justice Smokino Wanjala recognizes it for what it is. Academic, which is giving academics, I'm an academic, it's giving us a bad name. You know, we have academic, it was academic in the sense of being philosophical, being epistemological, being abstract. Basically semantics. It was an exchange in semantics. So that was not a proper forum for it. We have fora like this to debate it. We have academic conferences, seminars, webinars, symposia, and colloquia, and we have enough. So the High Court and the Court of Appeal were not the appropriate fora for this exercise in semantics and deep philosophy. And I think at one point I had some lawyers exchanging that, you know, Professor Rosenai has approved my understanding of basic structure doctrine. And I said, how does that help Kenyans amend their constitution? As scholars, we like debating, and we debate. It doesn't matter that it was based on a PhD dissertation thesis. It doesn't matter that it's based on a book. We have many books. We have written them. We write theses, we supervise them, we write them. But not every book, not every thesis is supposed to be a manual for amending the Constitution of Kenya. When these papers were being written, they were not manuals. In fact, they have understudied Kenya on most of those debates. The papers and books that were being cited have probably Kenya as a footnote. So those are some of the issues that we really ought to be clear about. So as we wrap up this, as I wrap up my contribution to this issue of basic structure doctrine, it is important to notice that there's structure which we are recognized in the Constitution, but not mandatory. There's issue of basic structure which is different, and as a phrase it exists, that there is a basic organization, and which sometimes have changed. Even the Constitution of Kenya, the structure at independence, the structure after the Kenyatta One amendments by 1969, the structure of the Constitution had changed. And even its basic structure had changed in the way the clauses were following each other or one another, and even content. And definitely the basic structure doctrine, when you say doctrine, it means as a deeply entrenched, accepted principle in law, in the Constitution, and in practice, when you add the term doctrine. And therefore, Justice Wanjala was right to say that it may be a school of thought, but for me, I wouldn't even call it a school of thought. And I think it was also very good that Justice Isaac Lenaola say? you know, in the High Court and Court of Appeal, we were being told that Justice Lenaola accepted the principle of basic structure doctrine in one of the cases. And we said, no, actually the phrase that was used there was just structure, maybe basic, but it was not a case that was talking about amendment of the Constitution. And therefore, Justice Lenaola was right to say, well, you are saying that I used it, I was saying that BSD, basic structure doctrine, applies in Kenya. No, I didn't say that. It's not my act. Non est factum. So let us understand that. It's not my act. I didn't say that. And I'm glad that lastly, Justice Ibrahim, who is the only judge who dissented on this case, was almost apologetic that, you know, I'm aware that that phrase has been used by some judges in Kenya, but I'm saying that I'm not suggesting that they were using it in the BSD language. So even in his dissent, at least the verbal presentation of his dissent was like maybe not used in Kenya in this context, even though I find that it's applicable in Kenya, but there's no history. There's no acceptable, well-received history of the, so basic structure doctrine is dead, long live popular sovereignty, because by the time basic structure doctrine in Kesavananda was 1973. Njoya is 2005. Njoya was amendment of the constitution through parliamentary initiative like India, only. There was nothing like referendum. And in Njoya itself was at the time not really based on the text of the constitution. It was a device to scuttle bombers, which it succeeded in doing with the relevant political consequences. But at least it made that contribution. We accept that it made a contribution to the significance of the role of the people in these processes. And therefore, even in Kenya, there is issues of amendment versus alteration. They are the same. Amendment is of course, the Constitution uses the word amendment, but even if you want to use alteration, it's the same. So by the time Kenyans lastly were adopting the 2010 Constitution, we were aware of Kesavananda. And some of us had debated this issue since our first year in law school, 1988. We were aware of this unamendability of the 4 steps, etc., etc. And the Kenyans said the steps to be taken in amending the constitution are in Articles 255 to 257. And therefore, the others do not apply, even the so-called mandatory 4 sequential steps. Because what is civic education? I know that it's been debated here that the Supreme Court said it's not applicable. No, the Supreme Court said public participation is applicable and was there. And the court, it was the duty of the Court of Appeal at the High Court to distinguish what they call civic education from public participation. Civic education as such is not textually referenced in the Constitution. We have public participation, which includes it. Then there is the issue of another step which they talked about was the Constituent Assembly. Njoya had recommended that we could amend our Constitution through a Constituent Assembly or referendum. We chose referendum. We didn't adopt Constituent Assembly, which we were being told in the High Court and Court of Appeal that were mandatory. Which means that Kenyans were aware about all this, but they chose a certain path. Let us respect Kenyans. Let us respect us. Let us not have to ask for permission from Dr. Devin D, from a High Court or any other court, or from Professor Rosrai on what to amend, when to amend, etc., etc. Because even the High Court, even the other courts were not sure what is the basic structure. Is it the entire constitution, or is it a case by case? Those are important issues that we need to address into the future, in the sense that as is, we can amend any aspect of our constitution through popular initiative. Because the constitution is about is, was, and ought to be. If Kenyans think that we need a basic structure doctrine because we can have Hitler, we can have Amin, and we have some of them who can wake up and dish money in gunias to amend a constitution, or bamboozle people and intimidate people and harass people and stone them. That's a different debate on whether we can entrench basic structure doctrine. And that will have to be made through appropriate amendment. But as of now, it doesn't exist. Long live popular sovereignty. Thank you.
Thank you very much, Prof. Ben Sihanya, for your very interesting school of thought. I want to invite Christine Konge to give us her perspective on the basic structure doctrine, the constitutional amendment and its limits. I see that this is the heart of the debate. So please do engage us. I see some chat coming in. I see some comments coming in the chat section. So you can also post this on social media. You can also bring on your friends, invite them into this discussion, because I think this is the most robust discourse on basic structure doctrine that there is so far. So over to you, Christine, for your thoughts on the same.
Okay, thank you, Julie. And I think I'll begin where Professor Sihanya has left, on whether we have the kind of persons who would corrupt the system or the procedures as provided under Articles 255 to 257 to engineer a result that would bring about serious unconstitutional constitutional amendments. And the question is, because on the basis of what the court said, on the reasoning, at least of the 6 judges, of course, Justice Ibrahim was dissenting. They did indicate that what is provided under Article 255 to 257 is sufficient to cure hypermendability and to cure unconstitutional constitutional amendments. Because of the internal safeguards that are provided under those articles. But let's remember, by the time the Supreme Court was giving its judgment, the only process that had not occurred under the BBI bill was a referendum. This was passed by the counties assemblies, except one, or the 47 except 2, and sometimes in record time. On the same day they get the bill, they passed the bill. Was the safeguards of civic education, public participation, despite our constitution met. The bills were also passed in short order at the National Assembly and at the Senate with no opposition. Was the safeguards we have under Article 255, 257 sufficient in terms of ensuring that people knew what was going to be passed, the reasons behind what was being passed? And remember, this was about 78 amendments to our constitution, some of them far-reaching. So in an ideal situation, I do believe if we were in an ideal democracy, those provisions would have worked as envisaged. In fact, the only step that was to happen was the referendum, and we hope that the Kenyans would have been able to, without the pressures, which we know were there. We know people were paid off money. We know cards were given. We know a lot of things happened to influence the process. So the good thing that, as Dr. Bhatia has said, is that even despite the summary given, there could have been I think there's leeway to challenge a process where, a clear and democratic amendment took place, like, something suspending the Bill of Rights and all of that. That's the reading we've gotten, because even though the summary suggests one thing, their reasonings to arrive to the decisions provide something different. And this also lends to the discussion I've actually been having in the past of where judges give individual judgments and have provided different reasonings to reach to a conclusion, which becomes the operative decision of the court, because it still does not give certainty. As Dr. Bhatia said, it leaves some room confusion as to what is actually the operative decision of the court if they have all used different rationale and different reasonings to arrive at the same conclusion. But all in all, I take this as an opportunity in this, as Professor Dixon has said, maybe pragmatic decision of the court to think that this could be the start of expanding the content of what our constitution provides under Articles 255 to 257. And I do also realize that the judges said, actually, there's a failing on the part of Parliament because this process is complex. It required a lot of judges. It required a battery of lawyers we had to get assistance from academics from different parts of the world to try and unpack this whole process. So even now, it means that at least the court mentioned there's need for a referendum law. There's a need for a law that will guide public participation in constitutional amendments for both processes, parliamentary and popular initiative. There's a need to know if the promoters of the bill only are responsible for civic education at the first step when they're collecting signature. What about who foots the bill for civic education, public participation after that process has ended? So there still needs to be a lot done to really bring clarity to this process. And what I foresee, even if another amendment process is started, it probably would result in court intervention if we do not have laws that give real guidance on each step of this process. Thank you.
Thanks a lot for that, Ms. Nkonge. There are unfortunately a lot of gaps in our legislation. So now I shall ask Dr. Abebe to kindly share his views on the basic structure doctrine and how it was canvassed by the Supreme Court, please. Thank you.
Thank you very much. First, I think I want to say Rose kind of touched on it, but this decision that from the High Court to the Supreme Court and the way it was done has extremely raised the profile of Kenya and in Africa. And so kudos to the people who started the process. I think it's important in building the rhetoric, the narrative that constitutions matter, civil society matters, and institutions matter. And I think in that sense, it was good not just for Kenya, but for Africa. So it was at a symbolic level, it was very, very, very important, and hopefully, some have tried to cover it as the exception that proves the rule in Africa. But I think it speaks to the fact that there is steady progress despite the challenge. So, and I think it also speaks to the fact that Kenyan democracy obviously has a lot of room for improvement, but it's robust, but it's also maturing. So I think in that regard, the entire exercise was critical. Now, in terms of my interventions on the basic structure doctrine, I'll try to divide it on from two levels. The first is from the procedural perspective. Now, if you look at the case, there were three issues essentially. The first one was whether the president was allowed to initiate the proceeding, and in connection with that, whether he actually did that. The second one was whether there was enough popular participation as required by the Constitution. And the third one was whether the constitutional amendment, the proposal, was substantively incompatible with the Constitution or the basic structures. There were three levels. And in my opinion, I think first the litigants, I don't think there was a deliberate, thought through litigation strategy, and partly that might be because there were so many applicants at the start. But I feel like they brought, all their guns blazing. They tried to use all the tools that were available for them. And I'm not sure if it was the strategic way to approach it, particularly given the fact that there was a relative confidence in the fact that the president could not initiate it, and perhaps also from the perspective of public participation. But of course, they probably wanted to go for use all their tools. But I think if they had thought strategically about how to go about it, they may have chosen to rely on the procedural issues and wait to fight another day for the substantive issue on whether the basic structure was applicable. And I'm saying that because there was always that trait that the courts could invalidate an amendment based on substantive grounds. And now, as Hougham and Christine said, it's still there. The threat may still be there, but it has been extremely smoothened, I would say. And I think so strategically they could have chosen well. And perhaps most importantly, the courts themselves First, in terms of the way they listed the issues, I think they should not have started on the most fundamental substantive issue. I think they should have addressed the issue of whether the president actually had the standing, the authority to initiate a process. And once they realized, once they get to the decision that the president did not have the authority, I don't think it was necessary and perhaps also not desirable to go beyond that, to decide whether there was public participation and most importantly, whether the basic structure was applicable in Kenya. And of course, if you look at it in the end, they talk about the importance of ripeness and all. But I argue that once they decide on procedural grounds that the amendments were not valid, I think the court should at least have explained why they thought it was desirable, that it was necessary to provide guidance on whether the substantive limit, the basic structure doctrine, was applicable in Kenya. And I think if they had left it out, the outcome would have been the same, but they would have maintained the leverage, the threat, and that threat could, of course, have implications and impact on political actors when they frame their ideas and all of that. Essentially, the court, the potential judicial challenge would have been an additional downstream veto, downstream constraint in addition to a referendum. But for some reason, I think the courts went ahead and discussed those two issues. Now, this is on the procedural issue. But again, fortunately, I think there's still room for a potential challenge on substantive grounds. It's not clear. It has been smoothened, the impact. It's not as sharp as it could be, but the threat is still there. So in that sense, not all is lost. In terms of the substance, whether some people have presented the decision of the Court of Appeal and the High Court as less aggressive than, say, the way the Indian Supreme Court and other courts in other places have done, because they have at least said you cannot amend the constitution, and they stopped there. But in Kenya, they said you cannot amend it in the way it was provided in the constitution, but you can do it in this particular way. But I dare say that, in my opinion, that the High Court was actually more aggressive. And perhaps Houghton knows better than me, but if you imagine a scenario in India or in other places in Colombia, where a constitutional amendment process actually follows the process that the Kenyan constitution provides, extensive participation, significant political consensus, and then also a popular referendum, I am not sure if the Indian Supreme Court will actually still invoke the basic structure doctrine, or for that matter, the Constitutional Court of Colombia. So in that sense, by considering the amendment process in the Constitution less robust and outlining their own idea of how the amendment process should be outlined, I think they went much further than they were essentially more aggressive, to put it that way, than courts that have invoked the basic structure doctrine abroad. Now, in terms of the judgment, I actually found overall, I found it well reasoned, and also I agree that every constitution has a basic structure, and certainly the Kenyan constitution. And in that sense, in fact, the Kenyan constitution expressly indicates what it considers are fundamental, right? It says, it outlines provisions, principles that it considers are fundamental. And at the same time, it says those fundamental principles can be amended. And I think then invoking an extra and implicit fundamental principle and saying that cannot be amended, I find it quite an extensive invocation. Now, this doesn't mean that the threat of regressive amendments are not in Kenya, or that the procedure that the constitution outlines can stop them. But I think if we put on a par, if we compare the process that the Court of Appeal and the High Court outlined and compare it with what the Constitution already provides, I would actually say that what the Constitution provides may in fact be more constraining than what the High Court outlined. In particular, the High Court didn't say anything as to how a constituent assembly would be constituted, for instance. Can, for instance, Parliament declare itself a constituent assembly, and would that suffice? And most importantly, even if it would be an elected constituent assembly, how would decisions be made? Would it be through a normal basic majority, or would it be through a supermajority as maybe provided in the current parliament? So it's essentially the only difference for me between the process that the High Court outlined and what the Constitution provides is the presence. You know, if you replace the Constituent Assembly and compare it with Parliament and the counties and all of that, in my opinion, actually the constitutional provision may be more robust. Now, is it sufficient to prevent regressive amendments? Maybe not always. And I think, as Christine said, in this particular case in particular, the only thing left was a referendum, and we don't know how the referendum would have gone. But ultimately, the courts have to recognize what they can legitimately do and what they can capably do. And I think they have read very well in the context of Kenya, and considering the robustness of the competitiveness of its electoral system, I think leaving some of the protection of the fundamental aspects of the constitution to the people of the country, to the political process, to the political discourse is I think defensible and perhaps maybe appropriate. I'll stop there.
We want to now move to two people who are in the studio who had quite a lot to say on basic structure. So we're going to move to Ochel Dudley and now move to also Mr. Elisha Ongoya, who will give us their thoughts on basic structure doctrine, as well as a few other things that have emanated from the discourse that they feel like they need to share with the audience that will give context to this discussion on basic structure doctrine. So over to you, Mr. Ochel Dudley.
That takes me back to the question, what is a basic structure doctrine? It's simply the idea that the power to amend a constitution is not unlimited, because that power is delegated. It's a secondary power. And making the constitution, or making it, requires you to invoke the constitution making power. I do not know how that is incompatible with people's sovereignty. If you say that changing the constitution is an act so fundamental that only the people can make it. In fact, the basic structure doctrine sustains the sovereignty of the people. It respects it. It says that some changes to the constitution belong to the people. And parliament cannot do it because it is a delegated organ. The referendum alone is not enough because it's also a constituted power. It is within the constitution. If the referendum is a forum within the constitution, then the moment the referendum, either in substance or procedure, steps outside the constitution, that act becomes invalid immediately. So the people must stand above the constitution and exercise their constitution-making power or constituent power, or sit in a constituent assembly, as DCJ Mwilu concedes, to change the constitution in fundamental ways. I want to say something radical, that the Supreme Court of Kenya decided 4-3 that the basic structure doctrine applies to Kenya. Justice Ibrahim decides it absolutely. Justice Mwilu finds on the fact and on the evidence, I almost quote a word for word, that I find that some of the proposed amendments are so fundamental that they exceed the limited scope of the amendment power. This requires recourse to the primary constituent power. That is a basic structure doctrine in action. The fact that fundamental changes to the constitution require recourse to the constituent power. She finds that, and I don't know why she doesn't disallow the appeal on that basis. Justice Smokin Wanjala says that he doesn't understand what primary constituent power is, though it allocates it one paragraph, though it was a question framed by the court. Still, that does not stop him from finding in the end that, one, the court will not allow any constitutional amendment which has the potential to subvert the constitution. Basic structure doctrine. Changes which alter the constitution must be subject to the primary constituent power. Then he says this, these 4 steps do not apply to constitutional amendment. However, in a constitutional moment, where the people decide to alter the constitution, then these 4 steps must apply. Basic structure doctrine. He also says that this doctrine is not a doctrine, a question we never framed. We never asked the court if the doctrine is a doctrine. All parties, nearly 100 Supreme Court counsel, were concurrent that there is a basic structure doctrine. Our only dispute was whether it applies to Kenya or not. So coming to that dispute, whether this doctrine applies to Kenya, Justice Smokin Wanjala says that this doctrine or judicial school of thought, whatever he calls it, is available to a court of law in Kenya in determining if a constitutional amendment has the potential to subvert the constitution. That is the basic structure doctrine. So if you count the votes, you have Justice Ibrahim deciding expressly that the basic structure doctrine applies to Kenya. You have Justice Mwilu deciding that on the facts of the appeal, the proposed amendments were so fundamental that they required recourse to the primary constituent power. Those are 2 votes. You have Justice Wanjala and then you have Justice Lenaola. Lenaola kind of walks the line. He says that if you want to make fundamental changes to the constitution, then you must go back to the primary constituent power. That still is a basic structure doctrine. In fact, it goes a step further. The other judges do not do it. Justice Lenaola defines amendment, and he finds that an amendment is consistent with the constitution. Then he also goes to dismemberment, finding that dismemberment is one that steps away from the constitution. Distinguishing those 2 aspects is the basic structure doctrine in action, finding that an amendment can only go too far because it is a power within the constitution, and that changing the constitution in fundamental aspects requires recourse to the primary constituent power or the constitution-making power is purely basic structure doctrine. So I don't understand why the vote count is 6-1 instead of 4-3. Allow me to come back to the lead judge, the Chief Justice Martha Koome. Justice Koome does not bother with what we call the constituent power, though it was a question framed by the court. The court had said, what is the primary constituent power? So is her analysis and conclusion that the basic structure doctrine and the 4 steps, civic education, public participation, referendum, constituent assembly, do not apply to Kenya complete without her answering that question? I say that had she answered that question, the question of what is primary constituent power, should have found for a fact that the basic structure doctrine applies to Kenya. Thank you.
Thank you very much. We are getting to a point where we will take questions. So first, I'd like to ask those who want to voice their questions to put their hand up in the chat section. I think there's a facility that allows you to put your hand up so that the technical team may enable you to voice your question. But we want to hear from Mr. Elisha Ngoya on this issue. Before now, we can go into the question and answer session.
Thank you, Julie. I think Chair Dudley raised a number of concerns that I would have wished to flag, but just one issue that Dr. Abebe raised about the case strategy, which bothers me all the time because case strategy is at the heart of my day-to-day operations, is that if you go to court unstrategically, then you don't expect much from court. But 2 things happened. One, the original filings in the High Court were not necessarily very coordinated filings, contrary to a lot of people's thoughts. These were different citizens coming to court from different backgrounds and different perspectives. So in terms of case strategy, different petitions came with different thoughts and different strategies. I mean, I litigated through the petition that questioned the distribution and allocation of constituencies as a distinct strategic question. But as the case progressed to the Court of Appeal and eventually to the Supreme Court, it just occurred to me that actually the case strategy that may appear to have been a hodgepodge of issues, if I may call them, was actually the best case strategy in the circumstances of this case. For what reason? Our listeners and our viewers may be glad to know that it is not often the petitioner designing the strategy who determines the tools of the struggle. Sometimes it is, and I use this word loosely, the enemy who dictates the rules of the struggle. For example, reading the provisions of Article 255 and 257 Dr. Bebe sees them as fair safeguards. But Mr. Chel Dudley is in Kenya on the ground, and he knows that one of the safeguards is the county assembly that is supposed to give a robust thought to this bill and make an informed, dispassionate decision on it. And he sees his president offering every member of the county assembly 2 million Kenya shillings, approximately 20,000 United States dollars to every member of the county assembly. He sees an independent constitutional commission, the SRC, approving this proposal in a record 2 weeks. Those of us who know how institutions in this country ordinarily work, how the judiciary begs for finances to run basic operations, no, it is not normal for the SRC to consider and approve financial expenditure in 2 weeks. When you are faced with that kind of a struggle, you then discover that you are frail. You have no corresponding resources as a civil society organization or as a civic conscious citizen to mount a defense. You throw anything at it. You begin throwing all stones and all leaves and all straws at the enemy in the hope that one of them may prick the enemy in the eye and he may not see you properly and you may defeat him. That's the context in which all these issues then ended up being thrown at the court on the clear understanding that they are arguable issues, number one, and that they give the litigation team a realistic chance of getting the court to agree with 1 or 2 or 3 of the issues. And that's what happened actually up to the Supreme Court level, whereas the petition, the appellants in the Supreme Court won on a majority of the issues, they still lost on the ultimate prize. Is the Constitution of Kenya Amendment Bill 2020 constitutional or unconstitutional? So on the ultimate prize, the respondents ended up winning in that context. But I'm just saying that in terms of the environment and the context, Kenyans on the platform know that within 2 or 3 days of this bill being taken to county assemblies by the IEBC, Siaya County Assembly had passed it. So within 3 days. So you are saying, Dr. Bebe, that there are sufficient safeguards. Of course, the safeguards presumes that there is a debate over the issue. A county assembly is approving it in 3 days. When did they listen to the residents of that county? When did they conduct meaningful public participation? When did they, even themselves as an assembly, debate among themselves to look at the merits or demerits of this bill? It's in that context that one says that, and I agree with Professor Hanya, obviously, that a Hitler can happen, an Amin can happen. Somebody may use the power of demagoguery to run roughshod in the process of Article 255 and 257. What do we do in those circumstances? To be honest to all my viewers and listeners, I saw exactly that with the bribery on members of county assemblies. I'll be lying if I saw anything else. The take home for me from the Supreme Court is the reasoning of most of the judges that we are not saying your hands are tied when somebody begins abusing this process. That gives a lifeline to all civic conscious citizens on a future date when confronted with similar helplessness to still consider the court as an appropriate forum to take this struggle. That's what I wanted to emphasize. Back to you, Judy.
Thank you very much, Mr. Elisha. Thank you very much to all our panelists. I think the robust engagement on the basic structure doctrine is what all our viewers and all the participants who came on board this webinar wanted to hear. So now we want to hear the voice of the people behind the screens, the people behind the laptops and phones, and what they have to say in this process. So we will field a few questions. There are quite a number. So I would urge my panelists to take notes because some of them will be directed to you. We'll start with Sam Gure, who posited this question around presidential immunity, and he states, on the question of presidential immunity, can the president's spouse file for divorce during the pendency of the presidential term? The senior counsel's language seems to prescribe any possibility of the same, or the Supreme Court's language seems to prescribe any possibility of the same. I think from our panelists, we can discuss who will take particular questions, then we will appropriate them fairly. Karoga Mogo states, On the question of presidential immunity, is it in order to say that the immunity was waived and the president abdicated in appointing the 41 Court of Appeal judges, I believe 41 Court of Appeal and High Court judges, as required of him under the Constitution? We have a question from John Alanamu, who's watching, and he asks, what does the Constitution say about the interlink between the executive and the judiciary? Kindly expound on the following: the popular initiative and the parliamentary system. We have a question from Lewinsky Imuhira. On the question of presidential immunity, why is it important for the person in office to be protected against criminal and civil proceedings? From Mr. Fergus Kerrigan, and this is an assumption, it could be a miss, my apologies for that. From Fergus Kerrigan, the question states, on the question of presidential immunity, it would be useful to go beyond the comparative question, how the provisions of the Kenyan Constitution compare to other constitutions, and to ask whether the provisions are successful in fulfilling the purpose of securing executive accountability. We have a question from Justice Ouko, and the question is, the president has not appointed some Court of Appeal judges as advised by JSC. Could this be one of the omissions the president, whereby, or rather, could this be one of the omissions by the president, whereby he can be sued through the Attorney General's office? I think that one I'll be partial and say Christine should answer that one. We have a question from Mr. Christopher Gitari, the Vice Chairperson of the ICJ Kenya, who asks to Dudley specifically, on the comment on the quorum of JSC versus IEBC, he asks, is the comparison that of oranges and mangoes? These are two different independent constitutional commissions. Christopher Nyabira asks, on the referendum question, is it the Supreme Court making that point? Because the Constitution requires the IEBC to determine the referendum question. It is proper to wait until they have exercised that authority before it becomes a dispute for the courts to resolve. I believe the Supreme Court made the correct judgment because the IEBC is an expert on this subject, which the court should consider in the event the matter goes back to court in a later time. I think I'll invite my co-moderator to go through the rest of the questions. They're quite a number.
Okay, sure. There's a question here from Peter Wendo, who was part of the introduction under Konrad Adenauer. And he says that in the Kenyan system, even if the president does not sit in the three houses, the president has control over the houses by virtue that they control members of the houses through their respective political party systems. So I think this question or this comment I shall pass on to Professor Sihanya. There's a comment which in part is a question from Harrison Mbori. The constitutional interpretation methodology suggested by Professor Sihanya is a great idea in any interpretive endeavor. In fact, it's a three-pronged methodology, which is a mirror image of the methodology in international law under Article 31 and 32 of the Vienna Convention on the Law of Treaties. Unfortunately, we don't have that right in front of us. However, and in my view, unfortunately, the text in the Constitution of Kenya does not have such a methodology. On what basis is the three-pronged interpretive methodology supposed to be the holy grail, as you've suggested? If anything, Article 259 on construing the Constitution seems to be quite clear on the approach to international law and customary international standards. So I don't know if you want to. There's a comment from Topua Lesinko, who's an advocate who was also part of the BBI proceedings. And he says that on the applicability of the basic structure doctrine, the Supreme Court misconstrued the petitioner's case. The Supreme Court was not told that the basic structure doctrine was applicable because it has attained some supra-international status, viewed from the lens of international law, strictly speaking. Rather, the argument was that it's a progressive constitutional doctrine that affirms the sovereignty of people whenever the constituted powers seek to substantively amend the Constitution. The Supreme Court thus misunderstood the basic structure doctrine from the beginning, and it embarked on a frolic of its own. I think I'll give that comment to Senior Counsel Ongoya, would you like to take that one? Thank you. Okay, thanks Topua for that comment. There's another comment from Mayo Alfred. He says, I agree with Peter Wendell. The president doesn't lack an avenue to pursue a constitutional change or fix an issue. President in this context is a party leader and can use either the majority leader or minority leaders in case he's on the minority side to move parliament to effect the changes he believes to be necessary. It was important to cushion the process from megalomaniac leaders, that's the exact phrase that he's used or she's used, to avoid use of public resources to influence the amendments of the Constitution. I think that's just a comment, a passing comment. We have another comment from lecturer and lawyer Colbert Ojambo, which says that in the Kenyan system, even if the president does not sit in the three houses, the president has control over the houses by virtue that they control members of the houses through their respective political party systems. So this seems to be a resounding gong from three members of the audience. I think it's already been assigned. So I think let's canvass those questions for now, because time is not on our side, unfortunately.
Thank you once again. This is a very important debate. Two questions and a very issue that came from Dudley on JSC and IEBC. One, the issue of Mr. Peter Wendell and two other comments to the effect that the president doesn't sit in those houses, but as a matter of fact, the president controls the party, is a party leader, can use the majority leader, minority leader, etc., etc. I think that comes from logic, not from text. Let's go to text. The Constitution in Chapter 6 requires even that state officers not be officials of parties. However, given the practice and the history of Kenya, the president and the deputy president have retained their roles in political parties as a matter largely of constitutional practice and history. Are we hearing today that we want to endorse this idea? And secondly, that to me is like, well, if you are the president, manipulate the party structure, use it to receive your political agenda, not really national agenda. And it's also based on an assumption, which many times is wrong, that the president will always have the so-called majority leader on their side. Most of the elections in Kenya and Africa have largely been rigged to give those numbers either at presidential level or in the legislature, with complete with an algorithm. So let's not assume that what has happened in Kenya, for example, in the 2013-2022 dispensation is what will always happen in Kenya and in the world. You will notice that, for example, the elections of 2007, which have now been confirmed to have been rigged, the person who was announced to have been a president, Kibaki, had very few seats. He was later announced to be president, but luckily we know what really happened. So the president in Africa will not, in Kenya and Africa, we don't always have so-called majority leader, majority as a matter of fact in the houses. Many presidents have won legitimate elections, but with a minority in the house. I'm talking about text, structure, and history in that regard, not so much what a progressive history, not history whereby the process has been frustrated. We are here because things have gone wrong even since 2010. We wouldn't be here, by the way, debating these issues if Kenya had been governed according to the constitution. We wouldn't be debating a lot of these issues about how to amend the constitution in the future. Because in my view, I think we are amending partly because to make sure that the inclusivity issues which were expected in the constitution are confirmed. The winner that takes it all is negated, etc., etc. Then there is the issue of, so let's just agree that into the future, the president, but if you were to amend the constitution according to the proposed BBI, then you would have some members of the executive in the House, but the members of the executive would be a minority, and therefore the separation of powers would still be retained, etc., etc. Because I think that the spirit of the history and spirit of history is also spirit of 2010 constitution was to try and remove the president from the day-to-day politics, party politics, politics in the floor of the House. That was the understanding if you read the BOMAS materials and Committee of Experts materials. But that has been negated by the practice that emerged under Uhuruto bromance and Uhuruto administration. So let's not try to confirm that bad practice. The second issue is that where the political party processes and parliamentary processes are manipulated. That's what I'm saying. We cannot say that should be the practice going on. The second question, which is also equally important comment and question by Mr. Mbori, was to the effect that who says that that three-pronged methodology of interpretation is the best, and does it have textual authority? Yes, and whether you want to argue from a textual perspective, and by the way, my understanding in this debate is that text is a consummation, an abbreviation or itself of history and intention of the people. Text is not just a dry piece of black letter, especially with regard to 2010. That text is a summary of our constitutional history and our constitutional struggles. And whether you want to also argue from a textualist, structuralist, functionalist perspectives of Max Weber, Karl Marx, etc., you'll find that text is important. What is the foundation of my three-pronged constitutional interpretative methodology in the text? You can find it in the text. What does Article 2 say? Article 2 says about the supremacy of the Constitution, and it says this Constitution, this text. So it begins with this Constitution and this text. Then the others come through what you would read in Articles 258, 259, and 260, which is about interpretation and construction, including holistic, including having regard to history and culture. And some scholars call structure legal culture, legal culture, etc., because culture and structure are very, very closely related, and that holistic approach. I think that my colleague here on the panel, Mr. Dudley Ochiel, has talked quite a lot about JSC versus IBC, and I'm glad that Mr. Gitari has said that those are apples and oranges. Just briefly, there is a requirement under JSC, the composition of JSC, that we know who the chair will be. So in the Dudley theory, it appears that the Chief Justice may not be there in JSC, and they still would have a quorum. Really? No, Justice Dudley, no. The Chief Justice is a requirement in the JSC. But what so there must be a fundamental issues in composition of those commissions. And for JSC, there must be a chair, and that chair must be the CJ. So that theory of AG and the two, it doesn't arise. So I think let's dispose of that way. The last for me is that if we want to review the issue of compositions of commissions in the future, yes, we can talk about it. But as of now, Con Law 101 says if there is a conflict between the Constitution and any statute, the Constitution shall prevail. And so it is. And the Supreme Court was very careful. I think the Supreme Court was saying that at all material times, it was properly constitutional. It's not saying that even in future, and there's a difference between constitution, composition, and quorum. And many times, quorum must be smaller than constitution and composition. Or it may be the same, but in any case, it many times is smaller. Justice Dudley Ochiel, Chief Justice Dudley Ochiel, also took us through a very long statement about how he thought they actually, wishful thinking is good. He was wishing that they had actually a 4-3 vote on BSD. One statement, Justice Douglas Shell knows very well. He's a very intelligent lawyer. He knows very well there's a difference between obiter dictum and ratio decidendi. What does that mean in Nairobi English? Obiter dictum are statements which judges say as a by the way. That is not the basis of the decision. These judges, and in a long speech at 943 page document, there are so many things that people say, even us as scholars. Sometimes we even apparently contradict ourselves in our essays. So what matters most is the ratio decidendi, the reasoning, the rationale for the decision, not the obiter dictum, not all the words that you use. Justice O'Shell knows that very well. Thank you. So you still don't have those 4-3 votes. We have 6-1, and even that one was apologetic on BSD. Justice Ibrahim, thank you.
Thank you. Thank you. I'll try to go next to the questions. I'm surprised that Professor Zihanya says that the reasoning of these 3 judges on the basic structure question, which was an issue before the court, submitted on at length by all the parties, and the judges apply the reasoning on it, can ever pass the test of obiter dictum. My understanding is that once the judges are pronouncing themselves on an issue before them, submitted on by the parties, that's the classical definition, the teaching aid of a ratio decidendi. So at least let me lay that to rest as a matter of principle. But having said that, let me deal with a couple of issues that our interlocutors have raised. Number one, the question that Sam Ngure raises is the question that was raised in the High Court by the judges. And in the course of our submissions at the Court of Appeal, I think it was Justice Kiage who raised it. That let's look at the net effect of defining this immunity and its scope. And he talked about the president walking in his marketplace somewhere in God knows which village, and randomly running roughshod on everybody there, whether you will tell that person, wait until his term ends. And Sam Ngure raises another question here. When the president is abusive of his spouse, physically or emotionally, is that spouse entitled to remedies under the domestic violence law in this country, where you can go for some court's intervention to exclude him from your space, for example, so that you are able to enjoy the peace? Or will you be told, no, he's serving his first year in office, he may be re-elected. You wait for that violence for the next 10 years when he has finished his 2 terms, then come here for office. Or not even his own spouse, another person's spouse, in which case that person desires to join him in a divorce cause as a correspondent. What option is available to that person? These questions were raised in the Court of Appeal. Unfortunately, you notice the Supreme Court didn't ask very many questions. In fact, the mode of asking of questions of the Supreme Court was novel. It was type that I have not come across. You make submissions first, all of you sit down, then you sit in a tutorial kind of engagement with those questions much later. So that is an approach that was new. I'm not saying it can't work completely, but it was a bit novel. But where the questions were asked, these questions were asked, and the judges reached that conclusion that no, this immunity is not absolute, having posed this kind of questions. I would have wished that the Supreme Court, being a Supreme Court, would have engaged with all these questions, that it frames an immunity that helps on questions of this nature. Let me just briefly, because of time, deal with Topua's question about the applicability of customary international law standards. Number one, no one raised it in pleadings, no one raised it in written submissions, no one raised it in oral submissions. It came out for the first time in the judgment of the court. And I've argued elsewhere that the pen and the mouth of the judge have legitimating character. What a judge writes and speaks assumes legitimacy. When you have such immense power to grant legitimacy, and like myself and Prof. Zihanya, who can speak about many things in class, but that's it, there are opinions here and there. What a judge says has legitimating force, that power must be exercised with extreme humility. You must be able to tell the parties when they are still before you, there is this matter weighing heavily in my mind. Are you suggesting that the basic structure doctrine applies here by virtue of customary international law? Then the party can say, yes, that is what I'm saying for reasons 1, 2, 3. Then you can respond and say, no, that has not gotten sufficient, state practice to meet that threshold. But not, when it comes out in the judgment, you gnash your teeth wherever you are. You say, number one, I never said so. The court said multiple times among those judges that we have looked at the comparative jurisprudence, and this jurisprudence is only from domestic courts. Those are domestic courts interpreting domestic constitutions. We have moved in Kenya a domestic court to interpret a domestic constitution. It then becomes painful to the ear to be held to account on a standard you didn't invite the court to apply, a customary international law standard. So to that extent, Topua's criticism then bears merit, that the judges may not be wrong, yes, but they leave more questions than answers. And unfortunately, once the judgment has been delivered, you must wait for another appropriate case in which a similar case will arise for you to be able to deal with this. Supreme Courts, as we know them, are not forums where you go every other day. It may take another 20 years, another 50 years or thereabout. So that becomes an opportunity that is gone like that. So in the interest of time, I think I'll defer to other people to respond to the other questions, Julie.
Thank you very much, Mr. Ongoy. I want us to leave the ICJ house for a minute and go to our online panelists. I would like to invite Dr. Gautam Bhatia or Dr. Adem, whoever might want to go first, to actually chime in on the various questions that have come out. I think you have isolated a few questions that resonate with you and you feel like you want to address them in the chat section. So I think I'll start with Dr. Gautam Bhatia. Do you have any questions that you wish to address yourself to from the chat section from our various participants? Thank you.
Yeah, I think I'll briefly refer to a question by Enoch, which is the panelist thought on the Supreme Court's depiction of the Court of Appeal and the High Court as applying foreign jurisprudence with unthinking deference, and was that fair? And I just want to, I think, briefly say that I thought that the consideration of foreign jurisprudence, in all three courts was actually was really good, and all three courts, although they took differing views on the applicability of these judgments, they consider them on their own terms and engage with them carefully. And the example that I have is, again, I mean, the classic case that begins it all, the Keshananda Bharati case in India, right? And there's this, and the entire debate in all three courts was that that because in India Parliament has plenary power to pass amendments. The Keshavananda Bharati case was passed in the context of the court safeguarding the constitution from Parliament. In the Kenyan constitution, Articles 257, that risk has been addressed through the tiered amendment structure, and therefore Keshavananda Bharati is not applicable. So that was the contention made. And the High Court and the Court of Appeal says that they don't say that we are picking up Keshavananda Bharati and taking it hook, line, and sinker and applying it to Kenya. What we are saying is that the very fact that the Kenyan constitution has this tiered amendment structure is the reason why Keshavananda Bharati will not be directly applied, but that the articulation of the basic structure doctrine in the Kenyan context has to appropriately be modified, and giving the judiciary in Kenya a more procedural role, where once you identify what the constitutional amendment violates the basic structure, the remedy is not that the court strikes it down, which was the Keshavananda Bharati Indian remedy. The remedy is that the court basically then requires that the four-step process be initiated. So unlike the basic structure doctrine as in the Indian context, which specifically makes certain parts of the constitution unamendable, that's beyond amending power, the High Court and the Court of Appeal say that every provision is potentially amendable, just that the procedure will vary. And I think that's the case when you look at all the other foreign judgments that they refer to. The Supreme Court takes a different view on, so in the Supreme Court's opinion, the tiered amendment process is meant to be an exhaustive internal constitutional response to the Keshavananda Bharati problem, which again, I think is a legitimate view to take, and is a different reading of that case and its applicability. So I think that all three courts, were very cautious and very careful in their reference to foreign precedent and how they used it. Whether we disagree or agree with their final opinions on that point, and of course, subject to the fact that the Supreme Court's actual finding on judicial review of amendments is still, in my respectful reading, it's an open question, as Ochiel said, is a little open whether it's 6-1, 5-2, 4-3. I think that still remains to be seen. Subject to that, I think that the use of foreign precedent, I think across the board was, for me as a foreign scholar, I was quite, I really admired the way that the Kenyan courts at all levels engaged with foreign cases and the care they took doing that.
I want to move to Dr. Adem, just for your quick comments.
Well, thank you again. And I think, I want to be specifically addressing issues in the judgment, but I think what I can say is that all three courts agree on the identification of the challenge that Kenya has historically faced and continues to face. And that is that you have a dominant presidency, and there has been at times an abusive resort to the constitutional amendment process. So they all recognize this. Where they had differences was on how they thought how that should be prevented, constrained, that's one. And secondly, on who should have the ultimate say on those things. And obviously the High Court and Court of Appeal went, if you will, for glory. So they said, they thought that not only that we don't trust our politicians, but we also don't trust that there is enough in the constitution, in the current constitution, to stop them. And they provided for procedures that they thought were appropriate. Now, the point that I was trying to make was that I think they should have been more modest, and I think the Supreme Court became more modest. That is one. And secondly, and I think this is a pragmatic issue, I think the procedures that the High Court outlined are objectively not more strict. And this is very important. They are not more strict. They are not stricter than what already exists in the Constitution. And in fact, in my opinion, they may be less so. And secondly, I think the High Court may actually have been, if you think about it in the long term, may have been defeatist in the sense that if you think about who can satisfy those processes, which particular actor in Kenya can follow that, it's a president. Now, depending on how you see it, can the president then, draft something, engage the people, and then directly call for elections, order the electoral commission to organize a referendum for a constituent assembly, and then that constituent assembly debates, comes up with something, and then goes for a referendum. And so essentially, if you think about it, that process may actually be weakening the protections that the High Court is trying to achieve. Essentially, it may be liberating the one person that could achieve it from the intricacies of politics, from going to parliament and all of that. And of course, I think there was an important point that Professor Ogonye raised, which is that how things were done were obviously very bad. The corruption and maybe it's not corruption, but the things that were done. And I think it speaks to the challenge of building constitutionalism. And so, we may be following the procedure, but it does not mean we have constitutionalism. Constitutionalism requires an internalization of the idea that power is restricted, that certain things must be, we have to act in good faith. Essentially, there's conventions and good faith and other things that come with it. And often these are difficult things for a court to enforce. So we may want this, we want these things to be there, but it can be very difficult to put it on a court to do this. It might, in fact, make them a target as well. Thank you. You are on mute. Yeah.
Hello? Can you hear me? Okay, thank you. I was just saying for a parting shot, I had requested for Christine and Dudley, but Professor Sihanya has asked for a final word, and I think by extension, our senior lecturer, Ongoya. So is this the end of the basic structure doctrine? What's next, and what are your parting views? Thank you.
Thank you, Val. So I'm just going back to a comment that Professor Sihanya said, and I'm just thinking about it on this quorum of the IBC. Yes, I do agree that one thing that the Supreme Court did with its holding is to legitimize all the actions that IBC had taken when there were 3 members. But he has also indicated that Section 29 by effect is now repealed. That's what he has talked about, laws which are inconsistent with the Constitution. So are you saying that as of 31st of October, IBC as constituted is unlawful? And they have been occupying office for the last 7 days unlawfully? Because I don't think that is what the Supreme Court holding was, except for Justice Njoki, who actually then went on to say Section 21 is repealed. The rest did not reach a similar finding. So the confusion then still persists. What is the final resolution of the matter? But ultimately, as Adebe has said, I think one thing about this whole process, it's actually shown how our constitution is meant to work. The fact that academics, civic-minded Kenyans were able to institute this very challenging, complicated legal issue to try and bring direction to how we exercise amendment powers in our country is actually a mark to the proper working of the 2010 Constitution. I think what also I take away from this is that the issues of constitutional amendment are not fully settled. There still remains unanswered questions. And even though, let's say, the basic structure doctrine does not apply to limit what can be amended by the Constitution, we still have options to test any other amendments for their, whether they are in line with the spirit and with the purpose under which the 2010 Constitution was created. I think there are little legal issues that need to be clarified moving forward as well. But I think all in all, I take great heart from this whole process. It was very interesting to us as constitutional lawyers. I was very excited and quite involved from this process from the get-go, just reading, interacting, hearing people's arguments. I think as legal scholars, as legal practitioners, this process has only made us better. And I think we owe a great gratitude to the people who have participated in this process from both sides, because ultimately, because of the vibrant participation of the Attorney General and other state agencies in this process is why we're also able to get such a well-nuanced outcome and processes from this. Thank
you. Hello, I hope everyone can hear me. As you give your comments on the questions that were raised and also your closing comments, we are pressed for time. Clearly, next time we should do a 5-hour webinar. I think one thing that a lot of Kenyans still ask is what happens to there might be few, there may be many, no definitive answer on this, but what happens to the progressive elements that were in the BBI? Can those be canvassed separately? And 10 years, 20 years from now, this process, what will it have taught us? Is this going to be a constitutional process? What is the legacy of the BBI? What, as Kenyans, can we take from this whole endeavor? So as you address yourself to the various comments, I think that is something you can conclude with. Thank you.
Thank you so much, Julie. I think the point Professor Sianya makes our case even clearer, that Article 250, one does not contain the word quorum. Neither does Article 171, which establishes the JSC. Find quorum in the Constitution, you will not find it because the composition of commissions are different. The Parliamentary Service Commission has 9 members, JSC 11. Others, which are not directly stated in the constitution, can have either 3 or any range of numbers up to 9. But the quorum is not in the constitution. The Supreme Court has fused quorum with composition. It has said that the IBC is competent if it has 3. That's the least number the IBC can have to make a decision, because if it's full, it has 7 members. The majority decision will be 4. The Supreme Court goes for 3 and says that IBC is fully constituted if it has the least numbers the Constitution allows it to have. And then the words quorum, I have said, do not appear in the Constitution, and the quorum of the JSC is set by the Judicial Service Act. We are told it's 6. You must have 6 of the 11 members present. By the reasoning of the Supreme Court, that we don't have to look anywhere else, we must stop at 251, which says between 3 and 9. Why can that same reasoning apply to the JSC? Why can't it apply to the Gender Commission, to the Commission on Administrative Justice, or any other constitution? What's so special about the IBC that only it can have the quorum of 3? But when we now say, okay, what about this other one? Then you begin to see why that decision does not make sense. And on the issue of presidential immunity, I blame the Supreme Court for the terrifyingly wrong decision it arrived at. I remember during the first day, we told the Supreme Court that, look here, you're only going to hear from the president and no one else on the issue of presidential immunity. You need to hear both sides. It refused to allow Dr. Jack Mimali, who's the only one who would address the court on that question extensively, to speak. He simply said no. We said, okay, give us 10 minutes to address you on this question. It's an important one. The Supreme Court said, no, we will read it. From the decisions of the Supreme Court, correct me if I'm wrong, but the court does not refer once to the submissions of Dr. Jack Mimali on presidential immunity. It doesn't. And we'd said that you cannot give the president absolute immunity. The Supreme Court says, no, he has absolute immunity. You cannot sue him, whatever the case. So today, if the president refuses to appoint the attorney general, according to the constitution, you must sue the attorney general. If the president refuses to appoint the attorney general, you must sue the attorney general. It doesn't make sense. It's an absurd decision, giving the president absolute immunity. And the Supreme Court does not attempt to define civil proceedings, because civil proceedings, that's understandable when we consider that point, that the president needs absolute immunity from civil proceedings, divorce, whatever, damages claims, but he must be liable for public law claims in judicial review. On the way forward again, I think the appeals chamber of the ESCJ will hear the last of these. The ESCJ has said that the standard of review for the decision of apex courts in the Katabazi case from Uganda is whether there's clear evidence that there was a palpable wrong or an irredeemable injustice that's evident on the face of the record. I think we can find something here that fits that test.
Thank you so much. Interesting. Three issues related. I like my village lawyer, Pan African and Kenyan public intellectual, and influenced by this education in the Senate. Three issues really. Number one is about issue of which Advocate Nkonge and Advocate Daniel focused. Is it okay? So as we sign off, right, okay. Proceed. Can you hear me? Yes, proceed. As we sign off, I want to use again a three-pronged typology, three-pronged approach. Now, what we have is on village heritage, lawyer heritage, and Kenyan and Pan African public intellectual and one influenced by Western education. Number one is the question that both the chair and the person can focus. And this is about what I'm just really.
Apologies, Prof, you're not still audible.
I hope I can be heard now. Sorry about the technological problems, challenges. I want to adopt once again, as we sign off, a three-pronged typology on addressing the issues. Again, influenced by the trilogy of the triple heritage. Village lawyer, secondly, Pan-Kenyan, Pan-African public intellectual, and influenced by Western education and Christianity. The three issues are, number one, the question that Advocate Dudley Ochiel and Advocate Christine Konge have focused quite a lot of attention on, and which is we all acknowledge is constitutional law 101. From the word ago, this was the simplest question to answer. It was the IEBC quorate. Did it have a quorum? Let me focus on what the Supreme Court said. There is a ratio decidendi, but then there is also the obiter dictum, the rationale for the decision, but also by the way comments. Just in summary, how was the question posed? Did IEBC at all material times relevant to this case have a quorum? The Constitution stipulates that it is okay if any of the commissions has 3 to 9 minimum. It has a floor and it has a ceiling. The numbers can vary in between. And the Constitution does not always stipulate quorum in all circumstances unless it found it necessary to do so, like the quorum of the Supreme Court being a minimum of 5, etc., etc. Or maybe saying a third, or maybe saying a half, a quarter, this number. It doesn't have to say it always. Nor do statutes which have composition and constitution of organizations always have quorum in the text. Sometimes they may have it, of course, in the schedule, which is part of the text, or sometimes in regulations. So it doesn't have to always have quorum, please. But once it has said that the composition is 3, minimum is 3, that means that if the quorum is 3, that is good enough, because quorum is not expected to exceed the composition. And this is not just a question of logic. This issue, I think, as I've proposed, we can debate it into the future on whether we have to go through all the commissions and say that in this one, 3, minimum of 3 would not be now, we would, etc., etc. But the people and the Constitution said that 3 for composition was good enough. And if then you are composed at 3, and then all of you are there, surely you have the quorum. And please, the point is, the Supreme Court said for all intents and purposes, it was not like saying, I didn't hear the Supreme Court to say that if IEBC has a number larger than 3, then it is illegal or unconstitutional. I didn't hear that. So I would really think we can have another discussion on that. But that's what my understanding is, that they focused on at all material times. That is the main phrase. But as of now, and my understanding is that if the IEBC has more than 3, that's okay. It would still be okay, constitutional. Number 2 is that how do we deal with these issues of reform into the future? And we are mindful of the fact that at least 4 million Kenyans signed on to this process. No process is perfect. Not the amendment of the US Constitution in 1791 that produced the 10 amendments was perfect. None is perfect. There are likely to be hitches here and there, but the reality of the situation is that, as a matter of fact and law, the Supreme Court found that the process was okay. There was only 2 challenges on the role of the president, which we have addressed, that these issues can be cured, and also on the issue of the 70 additional constituencies. So generally, and they think they were even very clear in their mind, and they stated it, that public participation was followed throughout the process, and this public participation, or PP, was only not followed, according to them, in the context of the 70 constituencies, the second schedule. And that the decision regarding the, especially the presidential role, poses a very major challenge into the future. We should have started by saying who is the promoter, rather than going into all those issues of popular initiative, which was not quite an issue, is not quite an issue. How does an individual, an ordinary Kenyan, a civil society organization, how do you master any of the following three sets of resources? Intellectual, political resources to bring about an amendment through a referendum, because this is an amendment that really is fundamental. Then how do you master the relevant or control or access the relevant economic and financial resources? Especially as described by both the High Court and Court of Appeal, this can be extremely difficult, if not impossible. And lastly, how then do you also deal with the logistics? Yeah, so how do you deal with those questions in order to secure an amendment? My final comment, therefore, is that thank God BSD is dead, and popular sovereignty is alive and kicking. Moving forward, we must also distinguish between constitution making, because these issues were conflated. What is the difference between making and constitutional amendment? And those are completely different. The 2010 constitution was about making, and therefore not everything that was done in the context of 2010 would apply. The 2020 issue was about constitutional amendment. It was not about constitution making. So with that, I hope that we can progressively, as Kenyans, move forward and discuss how and what to amend in the constitution, because the content of BBI has not been questioned by the court at all. And therefore, these issues of avoiding winner takes it all, ensuring shared prosperity and inclusivity, especially in tribal and other issues, dealing with that, addressing the agenda issue, the question of World Development Fund, the question of making sure that we address the woman question, the gender question, which we have not been able to address through various parliamentary amendment processes. Those are issues that are live, and we need to work on them as Kenyans to move this country forward. Saying no, 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 and with some people who have never been associated with any progressive reform or any reform at all is not an answer to our intractable and complex problems. Thank you.
Thank you very much, Professor Bensi Hanya. I want to just invite Dr. Adem and Professor Gautam Bhatia to give their closing remarks. And as I do so, I want to pose one question, a very controversial question, and I think the person I'll pose it to is well kitted to address it. Mr. Ongoya, in your closing remarks, please address this question. What does this jurisprudence say about how the court will hear the presidential petition in August? So ponder upon that as we go to our online audience, because that I know is going to take up a few minutes. So let's have the closing remarks from Dr. Adem and then from Dr. Gautam Bhatia. Thank you.
Again, I wanna thank everyone. I think it was a pleasure to be part of this. But in terms of the legacy, I think for me, I'll try and end where I started, and that is that I think in terms of the jurisprudential approach, I hope at least at some time in the future, the courts will actually clarify how they approach procedural and this substantive divide, and when they should start and end, because I think it's very critical in terms of how the entire jurisprudence is built. In terms of the substance, I think again, for me, the most important point is that courts have served their role, and that is that they have proved that they can stand up to a particular process. And this is important because in the future, whether it's because of the substantive vagueness in the decision or in the procedural requirements that they enforced, proponents of constitutional amendment would have to be careful. They would have to go to make sure that they comply with whatever the judges expect them to be. So, and I think in that sense, it will have impact beyond this particular event. But ultimately, and this touches back to the point I tried to make earlier, this, it's a process, and I think there is a progression towards respect for constitutional law, and particularly constitutionalism is harder, and it requires not just the behavior of political actors and the judiciary, but also the public at large. But I think I can say that Kenya in this particular decision has done Kenya itself proud, and certainly done Africa proud.
Thank you very much. Over to Dr. Gautam.
Oh, thank you. Thank you once again for inviting me, and I've really been struck by the generosity with which the Kenyan legal community and the larger community has been so open to engaging with foreign comparative scholars like Dr. Reve and myself. I think that shows both a generosity of character and a great self-confidence. That you're so open in that engagement. So thank you for that. I have two brief closing remarks. I think one is on the distinct and separate referendum questions. I think it has not been perhaps discussed in that much detail because the court didn't, left it, said it was unripe. I think that once the court finds that the purpose of the tiered amendment process is to prevent abusive amendments and hyper amendments, it follows that the unity of content approach has to be adopted the next time this question comes in a ripe fashion. Because if you were to allow for package deal amendments, then you would have something like the BBI amendment where 74 in one go, which is exactly what effectively hyper amendment means. You would go from no amendments in 12 years to 74 amendments in 12 years, and that is pretty much hyper amendment. So I think that it logically follows from the court's really strong finding that the tiered amendment process under 257 is meant to protect internally against hyper amendments. So then it follows that the referendum part of it, of 57, should be interpreted to allow for the unity of content approach. My second, and this is my concluding remark, is I think that there are, of course, many views on the correctness of the Supreme Court judgment, parts of it, and so on. I think for me, what is very striking is that at the end of the day, the court did strike down an amendment bill that carried the strong support of a large cross-section of the political class. So in that sense, it went against the really core interests of a large cross-section of the political class, which I think that when it's happening, it's often easy to forget how hard won that kind of judicial independence is, and how easy it is to lose that. And I come from India, where we had it for a very long time, and we are now in a position where our courts basically are completely unable to ever confront the executive on anything that matters. And we know that once you lose that, the road back seems so difficult, and really an uphill climb. And so I think that it's great that in Kenya that is happening right now. It's really hard won. It's very precious, and I hope that ability of the courts to really, when it matters, give judgments that the executive doesn't like, I hope that lasts long, because it's really precious, and it's really worth preserving. So thank you.
Thank you very much for your closing, and thank you for the encouragement that you have given the courts. Now I want to turn back to the studio audience and invite Elisha to give us his closing remarks, a bit of commentary on the question I'd asked earlier, and then we will have closing remarks from Christine Konge and closing remarks from Christine Konge, the ED of Katiba. So she'll wear two hats.
Thank you so much.
All right.
Thank you so much. I think I'm happy with the conversation. First, the frustrations Professor Zihanya expressed at some point in time are frustrations I share. For example, when one of the judges determined the unconstitutionality of the second schedule, reasoning that why did you do this through a schedule? And you see, Professor Zihanya would remember that one, that was not the argument by the petitioner who raised that question. There's an argument that arose in the submissions, and that if the judge found that weighing in her mind, it makes sense that you ask the parties to address you on it. Can we do this by a schedule? So the parties get a feeling that they have been heard. So I guess that you begin to understand the frustrations of this. You get this argument for the first time in the judgment. You've not had a chance to put your thoughts on the file, on the record, in the submissions. So for me, just in terms of judicial decision making, that is something that our judges can take home. That there's a frustration element in this. When parties come before you, present the issues, present the arguments, but you have side issues, only you know of them, you don't disclose them, you go and raise them for the first time in your judgment. That is something we can take home from this judgment without much ado. The second issue, and this is a clarification, Professor Sahanya mentioned there was no question on the content of the BBI bill. No, my case was all about the content, the constituencies question. So that's a minor clarification. I'm sure I'll slip of the tongue. The third issue for me is the legacy, and there are many legacies in this process. Positive ones for me are, number one, the availability of the judiciary for any citizen who feels oppressed. When I look at the character of the citizens who went to court, the Kenya National Union of Nurses, I mean, nurses are just workers, and you know, they are putting their resources together and trying to question this process. Mr. Alwochier, a farmer and arbitrator from Migori, somebody commented that he struck him as somebody who was doing some work in his farm. Then he just asked himself, why is the president abusing me and fellow citizens? Carried his jembe and said, let me go to Nairobi and question him. That to me is a positive thing. The caliber of lawyers who took on the machinery of the state. I mean, the state literally conscripted at least a third or more of the entire senior council bar to its side, at least a third. That is a resource you cannot easily get. The young people, kina Topua, the young people who are hardly 3-4 months old in practice, who took onto the task, appeared before superior court judges, looked at senior counsel of many years in practice, made their case, and stopped a governmental financed and backed process in its track. The level of civic confidence that this gives these young people is, to me, an important legacy. And you know, for me, the beautiful thing about this is that it is the nature of democratic struggles in this country. The people, if you look at people like Rait Murungi, people like James Orengo, people like, when they really took on the establishment of those years, they were really young men and young women in their 20s and 30s. People like Martha Karua, people like Chief Justice Martha Koome. They were young people. When I reflect backwards, I keep saying these were very courageous people. So it means that spirit of young people standing up to protect their future lives on. And to me, that's a positive thing, whichever way this matter is looked at. Of course, the intellectual questions remain from Professor Sahanya's observation that there may have been problematic issues with the findings on the ability of the president to raise this question. And from the observation made by Mr. Ochiel, it means that from both sides, we may be headed slightly far. We don't know where that will be. When we are taken there, we will know what to do there. And to me, this is a positive thing. It means, and you know, Dr. Adebe has said something very impressive. This puts Kenya, this puts Africa on the atlas. Positive things happening on this part of the world. We are not just a war-torn continent who have no civilized way of resolving our disputes. We have resolved one. To me, this is critical. And you know, for me, as a convener of the Avid Readers Forum at Kabarak University, the intellectual platform this has given us to enjoy and engage is an important legacy of the BBI process. The conversation will continue. Back to you, Julie.
Thank you very much. I think now it is my honor to call on Christine Konge to give closing remarks, but also her commentary on the discourse that has been taking place.
Thank you, Julie. Can I be heard? I think I can. Okay. So mine is just to add very little to what Professor Ongoya has said. And just to thank everybody as one of the organizations that was convening this webinar, and mindful of maybe there are questions still pending and people trying to understand the consequences of this decision. And we've just done a little bit of that because, as others have said, these three decisions will need to have quite in-depth analysis, actually, and maybe a series of other conversations to understand their full effect and their full impact, and what it means for constitutional law globally, but also what it means for constitutional law domestically. And I want to extend our thanks of appreciation for CAS, Konrad Adenauer Stiftung, to ICJ Kenya, to Katiba Institute, to the Avid Readers Forum of the Kabrak University for convening this session. I want to thank our able panelists for agreeing to come and share their thoughts on this. Professor Sihanya, Val, Julie, and yourself for leading the conversation, not forgetting Dudley and somebody we co-opted to become a panelist in the process, Professor Sihanya, not forgetting our online panelists, Professor Dixon, Dr. Batia, and Dr. Dede, for their views, irrespective of some terrible time differences. I think for that purpose, Professor Dixon had to leave because it's almost midnight or past midnight where she is. And thank you for our online audience for being with us and joining us. At some point, I think we're around 200. And I hope this conversation was useful, and maybe now to spur that those conversations should go on in your respective spaces. And hopefully then we'll be able to move the process forward in understanding what will be the next steps following from this. So thank you, everyone, and we wish you a good evening, good start to your weekend. Thank you.
Thank you very much again, and pleasant weekend to everyone.
Thank you.